Well, this notice that may be listed for admission on 29th, my lord. On 29th, next Wednesday, my lord.
Matter of which year?
Matter of 22, my lord. Obliged.
May I please, your lord? Item regarding item number 7, my lord. This matter I have filed affidavit in opposition, my lord, today morning, my lord. It will be taken up on Friday, my lord.
In from the other side?
Yes,
No,
my lord.
I'm from the other side. However, my lord, a short accommodation can be given a week's time.
Friday.
A week's time can
Friday,
be
my
given to file and reply to this affidavit in opposition if required, my lord.
Friday, my lord, the status quo is there, my lord.
On Wednesday next,
Friday.
not Friday. He'll let him file the rejoinder if required. Next Wednesday.
Much obliged.
I must P.R. Mohanto, learned Training Council, Revenue Department, submit that the affidavit in opposition has been filed today, copy of which, however, today, which, however, is not tagged with the record for para 3 or M. Bormon counts for the petition. However, submit that the matter may be taken up the next week to enable him to seek instructions as to whether any rejoinder affidavit would be required. Para, since urgency has been expressed and an interim order is
Monday, my lord.
Monday is a holiday.
Oh.
And an interim order is operated for this is on Wednesday, the 29th. Interim order passed, it continued to the next.
Much obliged.
And make a request, otherwise it cannot be taken.
My lord, admission matters next Wednesday, my lord.
Of which year?
2020, it is regarding without 23, my lord.
What is the matter of?
Matter is regarding, my lord, my vehicle was detained without requisition, my lord. No seizure memo was issued as of now, last 3 months, my lord.
When was it last?
23/6/2023.
Next Friday.
Yes.
Not this Friday, next Friday, next week.
Yes, my lord, next week.
By the time similar frame, the matter particular contractor the field match.
Contractor field.
2021 matter match.
21 matter, okay, next week.
Three matters.
All 21.
And 21 one matter and 23 two matter. But that was
23
only
matters,
mostly.
don't mention 23 matters. Mentioning out of turn is only for exceptional matters. 21.
In respect of item 5, once some little accommodation today, can it be on Wednesday, my lord? Next,
Here for the petition.
my lord.
Yes, taking the concept
In fact, the government advocate is there.
on the prayer of the SK Taluk, the learned council for the petition. Based on
29.
29,
Right.
5.
Deeply ordered.
May I please, your lordship?
Yes.
My lord, this matter may come up for motion on Friday.
My lordship, I beg to mention listing this matter on 4th of December, your lordship. Matter related to non-confidence motion passed against the petition. 4th of December, your lordship.
Come for admission.
Admission, your lordship.
Tenure is coming to an end in December.
Yes.
December, the tenure will be over.
No, your lord.
When?
I have no instruction, your lord.
December, the tenures are coming to an end, all 5 years. Gaon Panchayat,
Gaon Panchayat President.
you will have
May I please, Lord? Lordship, I beg to mention for listing on 28 matter.
what matter? Motion.
This is a matter related to demarcation of land, my lord.
What matter of which year?
2023, last posted on February 17th of February 2023, my lord. There
After
are some
17th February, it has not come.
No, not
The
listed.
next page.
obliged, Lord.
May I pray, lordship? Lordship, I beg to mention item number 13, lordship.
1-3.
Yes, sir. Lordship, kindly this matter may be taken at 2, lordship. My senior has some difficulties, lordship.
Who is the senior?
Mr. JST, lordship. I am appearing for KAC, lordship. I
Have
informed the petitioner also.
Have you informed?
Yes, sir.
Okay, we'll have it at 2 o'clock. Item number 2 o'clock.
Obliged.
Taken up. Yes.
May it please, your lordship, I beg to mention item number 22, lordship. In this case, we have filed one additional affidavit, lordship. That may come on record.
Yes. Taken.
May it please, my lords. With the concern of the other side, I beg to mention item 35. My lord, in this matter, now outstation counsel is being engaged with some difficulty on his part. Therefore, may I plead the matter may be listed any date after 15th of December, my lord, subject to lordship.
Here for the petitioner.
I am for the respondent number 8, my lord.
And for the petitioner, my lord. This matter is supposed to be listed for hearing, my lord.
22 matter.
Yes, my lord.
hearing, is it admitted?
Yes, my lord. On the last 22nd of September, my lord, an order was passed.
Item number 35.
35. Yeah.
What is the subject matter?
My lord, my certificate, scrutiny committee has cancelled my certificate.
Regarding
Caste certificate.
Caste certificate, ST certificate. There is an order of 22/9, my lord. And it was last listed in the
Yes.
hearing column on 14th, my lord. But however,
so this is the hearing call.
yes, my
And it appears that a prayer for adjournment has been made on behalf of the respondent.
Respond number 8.
Respondent number 8. So this petition has been listed under admission call. It appears that by the order that 29 common spirit was already. This court has also been informed that on a previous occasion, it was listed for hearing. But as agreed by the parties, as agreed by the council of the party for hearing on
19th, my lord. Can it be on 19th December?
19th of
Oh, like,
Public.
Wait, please, Lord. Item number 39, my lord.
Is there any interim order?
Item number 39, my lord. We have filed an affidavit in reply, my lord.
Yes.
I may be allowed to bring the same on
Yes,
record.
please.
And my lord, item number 62, my lord.
Yeah.
It should have been listed before the court number 13, my lord.
Correct.
Before the appropriate bench, my lord.
Item number,
My learned friend is there.
item number,
62, my lord. Supply orders, my lord.
Just for correction of orders passed at 4:30.
I've informed my learned friend for the opposite side.
correction,
Correction. It should be listed before the appropriate bench, my lord.
item number 60, it is submitted. That is I pertains to a prayer for correction of an order passed by Honorable Mr. Justice
Yeah, justice.
Yes, sir.
as the Court Kapara, raised to verify and list this case for the appropriate.
Deeply.
60.
If I may please, Your Lordship, I beg to mention item 56 from the supplementary list.
Yeah.
Consent has been taken from the other side, and the matter may be passed over for the day.
56,
56 from the supplementary list.
56 is connected.
With 55.
55, 56, both.
Yes.
When do you want?
Next week,
Taking the conseil for the
respondent number 2.
on a prayer made on behalf of the respondent number 2. Matter returned by a week.
I am for a petitioner. Lordship, get the interim, Lord.
Interim order passed to continue to the next year.
Lordship, if possible, can I date it? Date may be fixed.
Interim is
My please, Your Lordship.
Yes.
Lordship, I beg to mention for listing of a read petition for motion, Lordship.
motion is 21.
Or day after tomorrow, Lordship. Much obliged.
Lordship, I beg to mention for listing one item, writ petition
For
for respondent advocate Ms. Esther.
no, listing for what? Motion?
Motion.
Motion.
Yes.
Yes, motion.
May I please,
When?
Your
Day after tomorrow.
May I please, Your Lordship? Lordship, with the concern of the other side, I beg to mention item number 45.
Yeah.
My senior colleague is out of state.
45.
Right.
Yes. You have filed an general application.
Yes, Lord.
My Lord, I have the instruction, Lordship may dispose it of next week, Wednesday or Thursday, my Lord.
A prayer for adjournment has been made on behalf of the as council for the Kapara. S.K. Talukar, Standing Council Cooperation Department. However, the instructions have been received by based upon which the matter can be for final.
Wednesday,
On Friday next.
Uh,
Next
Friday.
week, not day after.
oh yes, the date may be given.
Lordship, interim is there.
20. Why do you? First, first, we'll have it on first.
Lordship, interim is
Okay, interim order passed earlier. The next step.
May I please, Lordship? Lordship, I'd like to mention item number 44 to be adjourned for today.
44. Here for whom? Petitioner.
Yes, Lordship.
Taking the consent of the other side.
Lordship.
If
My senior
take
is
the-
suffering from sudden illness.
Okay, we'll adjourn the matter, but we have to inform revenue department, madam. Some difficulty today.
Yes, Your Honor. Lordship, the matter may be
A prayer for adjournment is made on behalf of the petition. At least after 2 weeks,
listed 2 weeks.
4 weeks, madam. Have you filed your affidavit?
No, Your Honor.
Not a,
Still awaiting my instruction.
a petitioner. Also, it also appears that the affidavit that the department is yet to file response for Kapara in view of the above. List after 4 weeks to enable filing of affidavit.
Lordship, I'll have to check whether DC has to file or revenue has to
We
file.
have the respondent.
Yes, sir. Obliged.
Department of Respondent.
Lordship, I beg to mention for listing of the writ petition which has not listed after motion. Kindly list the matter on Friday. For
When was it last listed?
Lordship,
When was it last?
listed Lordship 25/9/23.
25/9. What is the subject matter?
Lordship,
What is the subject matter of the writ petition?
Lordship, there is a large plot of land and Lordship, litigation is going on for a small part of that plot. Hence, the petitioner is not able to sell the larger plot. Kindly pass the order so that the larger plot can be sold.
So what is the relief you are seeking from the court? If you come prepared with the facts, then we will consider not today. Come tomorrow. Next.
May I please, Your Lordship, I beg to mention read petition 3138 for listing on Friday in the orders column.
Now, writ petition is of which year?
This year. It was last listed on June of 2020.
What is the subject matter?
It relates to the permission of establishment of the company by the state government. So
Okay, next week.
much obliged.
Yeah, Your Lordship, I beg to mention one listing for WPC number 4453 of 2023. In order, Your Lordship.
Why out of turn listing? What is the subject matter?
Subject matter, Your Lordship, is the non-payment retirement pension benefit
Okay, pension next week.
next week. A date maybe.
We'll have it given it the next Wednesday.
Lordship, the matter has become infractured.
You want to withdraw it?
Yes.
You say that you are not saying that. If you want to withdraw, we can have it day after tomorrow.
Day after tomorrow.
Day after tomorrow.
May I please, Your Lordship?
Madam, have you got the relief? Why do you want to withdraw? The pensionary benefits have been received by you or not?
Pension, Your Lordship, we have not received the pension, Your Lordship.
Then why do you want to withdraw this petition? Take
Your
instructions
Lordship,
properly, madam. Not like this.
The last order 14/11/2020. Then again, it was again listed on 15/11/23, but the matter didn't reach.
Now, why do you want to withdraw the matter? I don't think you want to withdraw the matter. You take instructions properly. We'll have it next week or Friday or the pensionary matter. Take instructions properly. Make a mention tomorrow. Yes.
May I please, Your Lordship? Item number 19, 50, and 51, Lordship. Petitioner appear on online mode, Lordship. Is I allow?
Okay. Who is the petitioner?
SI Akan, Lordship.
Why he is not coming?
Because he out of station, Lordship.
Local council out of station. Okay, we have to accommodate, but better if he is present in the court. He is a council who is practicing at this court. Okay, we'll have.
May I please, Your Lordship? An application under section 438 CRPC Your Lordship, I am the owner of the commercial vehicle bearing registration number AS02CC 1035. Your Lordship, on 16/9/2023, the driver has taken the vehicle to the commercial stand for hiring purpose, and actually the vehicle is used for carrying goods on hire. But on that day, the driver has carried cattle. Your Lordship, I have no knowledge about it. Your Lordship, I have filed a bail application earlier and it was rejected by this honorable court on 1910. Your Lordship, Your Lordship, Zimmer petition is pending. Your Lordship, my humble submission. Kindly, I may be protected so that I can appear before the IO for proper investigation. Your Lordship.
Yes, those are PP, APP, APP, anyone? Mr. Burwa? Ask any of the additional PP. We'll have it after some. We'll issue notice at this. We can issue the notice. Your name?
My DM Khan.
DM Khan for the petition who has filed the petition on section 48 in connection with the court has noted that the prayer for anticipatory bail of the petitioner was rejected by the court on an earlier occasion by order 9/10/2020. What is the stage?
Your Lordship, I am the owner of the vehicle.
What is the stage of the investigation?
Your Lordship, investigation may be progressed.
So what is the stage?
Stage of investigation is on progress, I think, Your Lordship.
Call for the case.
Update case diary maybe. At the same time, Your Lordship, I kindly be protected, Your Lordship.
After rejection once, what are your new grounds?
New grant, Your Lordship, I may be arrested at any point of
What are
time.
the new
and,
grounds? This is an anticipatory bail. This is not a regular bail. You have to make out new grounds.
Your Lordship, my vehicle is under.
That is not a new ground.
I kindly be protected so that I can appear before the IO.
What are your new grounds, Mr. Counsel? Aren't you aware that you have to have new grounds in a second bail application?
Your Lordship, many days already over.
Many days over, are you behind the custody?
So Your Lordship, kindly, the petition is pending, Your Lordship, so that.
No, you have to cite new grounds.
Your Lordship, I am not the owner of the cattle. I have
That we had already noticed. Yes, what do you say?
My lord, it was earlier rejected, my lord. You may call for.
No, are there any new grounds cited?
My lord, no grounds. They have not given any new grounds here, my lord.
So why should we
My lord,
entertain?
not entered in, my lord.
Why should we entertain this?
My lord, no new grounds here, my lord.
Your Lordship, is in paragraph number 9.
9, yes.
Your Lordship, the investigation officer is calling me to appear. If I appear, I shall be arrested, Your Lordship.
Is that a ground? This is pretty good. Also heard
My lord,
Sharma,
my lord.
additional PP, who points out that no new grounds
My lord.
have been urged in support of the prayer for anticipatory bail. It is a settled law that to subsequent application for anticipatory bail could be maintainable, there is requirement to plead and make out new grounds which are not found in this case.
Right.
Accordingly, this petition is
Right.
and accordingly prayer for
Your Lordship,
anticipatory bail is
kindly
rejected.
update to.
No, no, my lord. Obliged.
This relates to after registration, no action has been taken, but we have got an instruction. FIR has been registered, charge sheet has been framed, and it has been charge sheet has been framed on 25/10/2023. Normally, in this kind of cases,
Maybe close my
post declines. So,
Or your yearly,
lord.
yearly learned council for the petition also heard Sri S. Barua, learned state council, who submits that instructions have been
Yes,
received.
yes,
Full stop. Para,
Yes, sir.
considering
Yes.
the subject matter in dispute,
Yes.
and also
Actually,
the instructions and also the instructions received, comma, this
Order
writ petition
to
is taken up for disposal at the motion stage itself. Full stop. Para, the petitioner is aggrieved by lack of action in respect of Tharupatia PS case number 174 of 2020 laws
order deputy court.
by one Sofeda Khatun, comma, President Golandi Gaon Panchayat against one 174 is not your case.
my lord.
174 is the case by the other side.
Filed by from our side, another FIR, my lord.
Now, what is the number of
My-
filed by you?
But actually, earlier two FIR was
Okay,
Fine.
right. In action, in respect of, and no, in respect of an Azhar caused by her. Full stop.
NXA.
It is the case of the petitioner that initiated Tharupatia PS case number 174 of 2023 was caused by one Sofeda Khatun, President of Golandi Gaon Panchayat, against certain persons in which the petitioner was directed to make her statement. Full stop. In the state process, comma, the petitioner was also assault and injured, for which he had lost an affair in which action in which, comma, it has been alleged that no action has been taken. Full stop. Para. Riyaz Barua and the State Council, however, submit that as per written instruction dated 21/11/2023, comma, the Azhar by the petitioner has been registered as Tharupatia PS case number 200 of 2023 under section 447/290/325/34 IPC, and certain persons were also arrested. It is further submitted that the investigation is over and charge sheet number 208/2023 has been submitted on 25/10/2023. Para. Apart from the fact that a writ court would be loath in entering into dispute of present nature alleging inaction in registering an affair or delay in investigation as per the settled law of the Honorable Supreme Court, within bracket, Supreme Court, comma, one of the cases being the case of Sakira Basu versus Twins, reported in Twins, comma, in the instant case, comma, This court has further noticed that not only the case has been registered, comma, the investigation is also over. Full stop, para. In view of the above, this court is of the view that the grievances of petitioner have been substantially redressed, and according to the written disclosure, para, copy of the written instructions dated 21/11/2023 in Parliament.
Three and four million was for instruction. Yes, in fact, permission of the district magistrate for taking physical possession, it is with regard to, yes. So that has been taken and an order has been received. Order has been issued on 17/11/2020.
You have a copy, Mr. Barua?
Yes, I'm
Just don't have it. You have an extra copy? Let Mr. Ganguly have a look. Yes.
Item 3.
Authority, this has been given.
Lordship, this is an item 4, and item 3 relates to Silchar. Item 4 is for the Deputy Commissioner Kamrup Metro.
That has been done.
That has been done.
Silchar?
And Silchar.
No, that instruction is with regard to okay.
This is
Yes,
3676.
yes. In both the cases, already the permission of the district authority has been received. Here,
But you can kindly record that.
Separate order. Three A Kanpuri Learned Council for the petition. All third. Three as Barua Learned State Council, who has submitted that written instructions have been received. Considering the nature of the grievance and instructions received from this written is taken up for disposal at the motion. The petitioner is the Punjab National Bank and has approached this court due to the inaction of the respondent authorities for granting necessary authority to the concerned officer of the bank to take physical possession of the secured asset mortgaged by the respondent number 4 and 5. It will be like in connection with the loan facilities extended and disbursed. Full stop. It is submitted that in absence of such authorization, the bank is not able to progress. Full stop. Sarah? As Barua, the state, however, submit that as per dated 21/11/2020, taken the concerned district magistrate has passed necessary orders in exercise of powers under section 14 of the Authority Act 2002 and has authorized a particular officer to act to do the input in terms of provision of the act. Sarah? In view of the effort that facts and circumstances, this court of the opinion that the grant of have been submitted and according to the rules, Sarah, written instruction dated date along with the enclosures are made part of the
Item 4 also.
But Mr. Ganguly, item 4, have you seen the instructions?
I have not seen.
It is item 3 is very it is very clear. But 4 there is also an order by the ADC. I think it is suffice.
2510.
Yes, this will suffice. Yes. It's ordered in a different manner. 3 item, the order passed in item 3 is more appropriate. Is more appropriate. I think.
No, the item 3, this is order of 2022. In fact, Malod, there is an issue here. In item 3, Malod, possession was taken, Malod, and I have stated, Malod, we have given the documents that forcefully, Malod, taken, the possession was taken again by the borrowers, Malod.
No, this is not 2022. This is 17/11/23.
My learned friend.
Yes, first one.
No, as so far as the other matter is concerned, Qatar matter is concerned, that is of 2022.
Yes, Malod. But 2022, Malod, we are asking for fresh permission because, Malod, in 2022, we have placed on record the relevant.
Then let us not pass orders in.
Yes, Malod, then in item 3, Malod, it can
3
be
let us dispose of 3. 4 will say.
No, I'm sorry, Malod. Item 4 can be disposed of.
No. You're
4 of
confusing it.
अपनी file of
Yes,
Guwahati,
yes.
Kamrup Metro Guwahati, item 4.
6376 is 6376 is Kamrup Metro.
6376, yes.
It's Kamrup Metro. That has been done.
That has been done. That is item 3.
3 we have disposed of. 4
Yeah.
I think 4 if you are raising
Four,
any.
Malod, then they'll have to file affidavit, I think, Malod, because the question is that, Malod, we have placed.
4 will say something else then.
Lodge.
4
Because, Malod, it apparently they are proceeding on the basis that once I have taken, Malod, I cannot take again. That cannot be done, Malod. That there is no
just a
bar.
minute. No, there is a case pending so far as the
Yes.
case is concerned.
Yes, yes.
In the civil court.
Yes.
No, civil court, Malod, the matter, case is pending, but there is no injunction or stay, Malod.
Doesn't matter, but
But there is no dispute.
will issue notice in this document.
In fact, the first page of the instruction contains the parallel comment. So the details of the case which is pending before the deputy magistrate.
Item 4. Third, P.K. Ganguly learned counsel for the petitioner against Punjab District. Sarah, the petitioner is aggrieved by the lack of appropriate action by the official to take physical possession of the secured assets in respect of mortgage to the responsible number
2, Malod.
2,
But mortgage created by
not 2, responsible 4 and 5.
4 and 5, yes. Created by 4 and
4, 5 and 6,
4 and 5, Malod. 6 is not there.
which is ML construction is what?
ML construction, Malod, is. That is in the Guwahati matter, Malod, not the.
Okay.
Again, confusion. Lordship is looking into 6389 or 6376, Malod, which one? 89.
There is a big confusion. Your instructions are on 6376 pertains to the other one.
Yes.
6376 pertains to a loan.
6376 is of Kamrup Metro.
No,
No,
that is what.
that is why the confusion is.
6376 is of Silchar.
Silchar. Item 3. And 4 is, my lord, 6389.
You open the petition. I think while registering from your side, you had done a mistake.
Numbering.
So the numbering,
Maybe while numbering.
yes,
the-
numbering.
Yes,
You correct it.
that is the
6376,
Punjab.
63, because the nomenclature is the same, so the
Yes,
confusion
yes.
has arisen.
Yes, yes,
6376 pertains to Silchar.
yes.
Silchar.
There-
So-
there's a-
Our order for disposal will be in the second 4, item number
6389, item 4.
item 4, 6389. Item 3,
Even numbering.
pertains to the private respond numbers 4. No, 6, no, 4 and 5. 4 and 5. Put up.
The Dusty may also be permitted on 4 and 5.
3. Percent the earlier order dated 10, 11, 20, comma 3. As per order, state council has obtained certain instructions as per which the authority for the fiscal protection was given in the year 2022 itself. 3. The Ganguly, the learned counsel for the petitioner, however, submit that the state authority could not be acted upon as what has happened.
No, my lord, it was indeed acted upon. Possession was taken. The bank took over possession, placed the security agency in charge. My lord, they forcefully entered into possession, taking advantage of Durga Puja.
No, though the physical possession was taken over, pursuant state authority, comma, the private respondent had forcefully entered, forcefully taken over possession again, for which there is requirement of a press authority. The written instructions, however, also mentions about a case in the learned court of the civil judge number 1, Qatar. That notice be issued returnable by 4 weeks. 3. Barua, the London State Council accepts notice on behalf of respondent numbers 1, 2, and 3. Parent, the extra copies of the and served upon him by tomorrow. Steps for service of notice upon the respondent numbers 4 and 5 be taken by registered post daily. Steps by tomorrow. Your elective trustee.
I'll try this thing.
Then 4 weeks date returnable on returnable on 14th of December. 14th of December. Sri Ganguly prays for liberty to serve justice upon the respond numbers 4 and 5. Liberty is granted and such justice service is to be routed through the registry of this court, and the notice accompanying the justice is to clearly reflect the next date. The petitioner is further required to file an affidavit before the next date regarding proof of such justice service.
Deeply.
You have
Yes, I have.
correct it.
Yes.
63893.
Yes, may please, your lordship. My lord, a writ petition is already pending with interim prayer, with interim order not to demolish my construction, lordship. Lordships, this seller took the permission in 2006, lordship. I purchased the property in 2020, lordships. Now, lordships, a notice is issued, lordships, for site inspection and setback measurement, lordships. And for this, lordships, I have approached Proportion Honorable Court. Already there is an interim order not to demolish, lordship. That impugn letter dated 4/11/23.
Now, what is your cause of action here?
Lordships, this cause of action, lordship, this as interim order is passed earlier, it is continuing. Lordship, subsequently, this order cannot be issued, lordship.
Which order? Page?
Page 101, lordships. Annexure 12, lordships.
The interim order is only for not demolished. This is for inspection.
Lordships, they cannot, because already permission was taken and site.
Now, how do you prevent an inspection? Where is the interim order? Let us see.
Lordships, lordships, that interim order, lordships, page 93, lordships.
Yes.
Operative portion 97, lordships.
Here, page paragraph 12.
Lordship,
Till 11/8/2023, GMD shall not proceed with the demolition of the illegal construction
lordships,
made in the land without the leave of the court, and there will be no bar to proceed with the proposed action after 11/8/20, subject to further orders. Now they are only trying to inspect it. What's the difficulty?
lordships, this GMD cannot go for measurement, lordships, because already I took the permission from the Gau Panchayat, lordships. Once this Gau Panchayat has, because my area comes within the jurisdiction of Gau
Those are the
Panchayat.
subject matter of adjudication, but how are you affected by a measurement exercise?
Lordship, already I took the.
You cannot preempt the authorities from acting in accordance with law. Your demolition, that will continue, but how do you prevent them from taking the measurement? Yes, madam.
My lord, this 101 my lord order has been passed as per the order of this honorable court, my lord.
You're only trying to measure it, isn't it?
My lord.
Demolition, you are not carrying out. So where is the cause of action?
Lordship, subsequently that regarding that demolition may come, lordship.
Then my lord.
There is an interim order. Where is the demolition order? And even if there is a demolition order, you have all the recourse in law. This is misconceived, Mr. Sharma. Or you're dismissing this. Or Sri R. Sharma, Learned Counsel for the petition. Also heard. MS Shutiya, Learned Counsel, appearing for
DMC, my lord.
DMDA,
my lord.
the appearing for DMDA. Dash this for numbers 1 and 2. 1 and 2.
My lord.
What about 3 town planner?
Oh, super.
Town planner?
My lord.
And 3. Put up. In view of the order proposed to be passed, notice is not required to be issued to the private respondent. Number 4. The petitioner is aggrieved by an order by a communication dated 4/11/2023, by which his presence has been directed along with witnesses for a site inspection of the building in question. The said building is the RCC structure of G+4 at Khanamukh, Guwahati food supplier. It is the case of the petitioner that the petitioner had earlier approached this court by filing WP 4091 of 2020 against an order dated 11/7/2020 by which the building in question was directed to be demolished, and after considering the response to the show cause notice submitted by the petition, in the aforesaid WPC, in the aforesaid petition from this court has passed an order dated 24/7/2023 issuing notice, and in the meantime it was directed that the demolition on the land of the petitioner shall not be proceeded without taking leave of the court. Full stop. For any reference, the operative part of the order is extracted herein below, page 97, paragraph 12.
My lord, page 97, my lord, para 12, my lord. There is another line, my lord, that there would be no bar to proceed with the further.
Madam, we are dismissing this.
Fine.
To understand what we are discussing. Para. It is the case of the petitioner that sorry. The said aforesaid interim order was extended by a subsequent order dated 11/8/2023. Para. 11/8/2023. It is the case of the petitioner that the notice dated the communication dated 4/11/2023 impute communication issued by the GMPA is the teeth of the interim order. Para. On the other hand, the learned counsel for the GMPA has submitted that the aforesaid exercise is not in violation of the interim order and is rather a step taken in compliance of the interim order, by which an inspection for the deviation and setback has been sought to be made, and there is no further action. In the opinion of this court, the impugned communication dated 4/11/2023 cannot be construed, in any manner to be in violation of the interim order passed by this court in the earlier writ petition WPC 4091/2023, which is pending, and is rather an exercise carried out to inspect the deviation and setback measurement. This court is of the opinion that there is no cause of action which should arise by issuance of communication dated 4/11/2020, and accordingly the writ petition is dismissed.
May I please, Lordship? Lordship, the writ petition has been filed by the borrower. A recovery certificate was issued against him because some credit facilities were given to them on security of two properties, Lordship, both of Guwahati. The borrower's property already auctioned in recovery process. The respondent number 3, who is the guarantor, his property is yet to be auctioned. In spite of having a mortgage property, the recovery officer is proceeding against a non-mortgage property of the borrower, keeping the attachment of the respondent number 3 guarantor property in alive. So the writ petition has been preferred, Lordship. Lordship, the guarantor has also preferred a writ petition before the Honorable Court, which is pending before the court. Your Lordship had already vacated the interim protection given to the guarantor in 2020. Since last 3 years, they have not proceeded with. Both of the petitions can be taken up together, Lordship. What do you?
Yes, Lordship, no problem.
Here for the bank,
Yes, Your Lordship.
Union
Respondent number one, Your Lordship.
heard the Saraf Senate Council for the petition. As per the facts projected, the petitioner had availed certain credit facilities from the respondent number one bank, and in connection thereto, OA 114 of 2013 was initiated in the DRT Guwahati.
Lordship.
Yes, Lord.
Full stop. It is the case of the petitioner that the security advanced by the petition as borrower has already been auctioned, and the guarantor had also advanced certain security in respect of state loan. However, instead of going ahead with the security advanced by the borrower, advanced by the guarantor, the properties of the petition which are not subject of the mortgage has been sought to be attached.
Has been attached.
Has been attached. But this court has further been informed that though the guarantor, who is the respondent number three, had earlier filed a writ petition in this court, being WP 4961 of 2018, and there was also an interim order. The same interim order was vacated by this court on 11/12/2020, and therefore there is no bar on the part of the respondent bank to proceed for attachment of mortgage property of the guarantor for number 3. That note should be returnable. When is any date fixed in the other case?
Lordship, the date has been fixed. The impugned order, Lordship, is at page 97. It has fixed the date as 15/12/2023, Lordship. So the proceedings may continue, Lordship. Just before auctioning the mortgage property, the attachment can be kept in abeyance, Lordship.
We'll have a date. We'll have a date before 15.
Lordship.
That will.
Lordship.
Lordship, actually, Your Lordship, as per my inspection of my senior Lordship, the entire property has been sold out as per the knowledge of me, Your Lordship.
Even
So
the
there is
that of the
something in there, Your
guarantor.
Lordship. Yes.
Even that of the guarantor.
Yes, Your Lordship.
Taken up before 15/12, Lordship.
Matter may be fixed before 15/12, Your Lordship.
Returnable on. We'll have it on 11th of December.
Yes,
11th of December.
I intend to file an additional affidavit, Lordship. There are some omissions.
But your name?
D. Saraf.
P. Agarwal. P. Agarwal.
P. Agarwal.
P. Agarwal. Your
P.
Lordship.
P. Agarwal. Senate Council accept notice on behalf of respondables 1 and 2.
One, Your Lordship, only.
What about recovery? Okay, 1. Put that extra copy of the writ is served upon him. Right, more that step to be taken service of notice upon honorable 2 and 3 by said post PJD, 7 by the court. 3. Agarwal, however, submits on instruction that the projection made by the petitioner may not be correct, as all the mortgage property in question has in the meantime been attached and sold. Sir, this aspect of the matter would be considered on the next date, prior to which the petitioner is also at liberty to file additional petition.
Obliged.
Yes.
Lordship, this writ petition is regarding non-implementation of certain orders passed by the appellate authority under RTA, Right to Information Act.
I am for the commission. We have passed the order, which she prays is not been executed or implemented.
Okay.
But we do not have the power to implement an order. The order has to, we can only pass an order. There is no power under the act which empowers us to take any
Now, how do
action.
you get it implemented?
So we have no option for that. No power in the act which.
So is there any penal provision in the act?
Yes, but only if there's a default in providing information in the appellate stage.
No, now there is a default. Provision has not been provided.
That is correct, but that is after the order has been passed.
But Lordship, you may
Also,
kindly
Lordship,
see the page 41.
4-1.
41.
Yes.
The para 7, here the column Roman 2, the public information officer, office of the
41, 42.
42, page 42.
Yes.
Last page. The public information officer, office of the Chairman Juha Development Authority shall furnish the information within 15 days from the date of receipt of this order free of cost if he is unable to substantiate the contention as mentioned above.
So let us issue
Let-
notice of this.
Lordship, also another part is the order is not conclusive. It says if you cannot substantiate.
But-
Let us have this
but-
view. Let us have. What is your name, madam?
Zedeka, Ms. Zedeka.
Or petition with the fifth non-implementation of an order passed order dated 19/5/20 passed by State Information Commission as second appellate authority.
Yes, Lord.
Yes.
Second appellate authority, whereby the public information officer in the office of the Jorhat Development Authority was directed to furnish the information within 15 days with a stipulation that if you could, if he or she is unable to substantiate the contention put to pass. The DDECA, Standing Council Information Commission has, however, submitted that the Commission does not have power to direct implementation of its orders. Be that competent notice issued, returnable on 15th of September. Urban housing, urban as per as government on and 4 is by DDEC Standing Council. 5 and 6. Jorhat Development Authority, madam, you can take 5. Jorhat Standing Council is there.
No.
So let's have to take it for the by research. Report extra copy. 6 steps by tomorrow. 5 and 6 research possibility. Yes. Item 10, Mr. Upadhyay.
This is property matter. Here, question is, my lord, I was elected director of the cooperative society. My lord,
You are
director
director.
of the cooperative society.
Okay.
I was duly elected. And what happened here, I raised a certain issue before that cooperative society.
Yes.
Then I was issued the so-called, and thereafter I was removed by the board of directors. And against that removal order, I filed an appeal before the register. Here the question is only whether the board of director can remove me. Only the General Assembly can remove.
Yes, Kaluda.
That I will obtain the instruction exactly what has happened. Doctor will give me some time.
What was the order passed by the appellate authority?
This is the order, my lord, the page number 152-7.
What does it say on this
It is
aspect?
statement with reference to subject. I am to inform you that your appeal petition dated 9/8/2000 has been rejected as the allegation raised by you are found baseless on the inquiry done by Sri Hiren Sharma, the sub-register. So this is
Now, Mr. Upadhyay,
my lord.
that is on the merits of the allegation. Now you are raising a different issue altogether.
I'll do
Issue of jurisdiction.
jurisdiction that I have raised in the appeal. Your
Did you
lordship-
raise that issue in the
Yes,
appeal?
yes, yes.
How
your
has
lord-
it been answered?
No, that has been not answered.
Kaluda, please
Uh,
notice that.
That, my lord, I will obtain the instruction whether the
Let him
appellate
take instruction and at the very
7 days time will
initial
be
stage
given.
it can be disposed of. At the motion stage it will be remanded back. It will be remanded.
How Upadhyay doesn't count for the petition. The petitioner who was one of the directors of number 1 Hajo Gaon Panchayat Cooperative Society Limited. The name is Hajo Gaon Panchayat Cooperative Society
Yes.
Number 1.
in the district of Kamrup was removed by the board of directors by an order dated 17th,
Resolution.
no, by an order.
It is so far. Reply. It will reply.
What is the order?
What is your lordship? I read the
Removal order?
yes. The page number 41.
Date?
Page number 41.
Page,
Yes.
date,
41. Page number annexer.
date of the order.
Date of 11/7.
By an order
23.
dated 11/7/2020. It is claimed that the aforesaid removal was the subject matter of an appeal before the registrar of cooperative society. The petitioner raises the issue of jurisdiction of the board of directors to pass an order of removal of one of the directors, which was also raised in the appeal. And the said issue, however, has not been dealt with. The S.K. Talukdar and Planning Council of the department, however, submit that some time may be granted to enable him to obtain just for motion again on 4th of December, 4th of December, to enable this understanding council to obtain that an extra copy
Yes, correct.
Yes.
of the written can be served upon by today, by during the court.
Yes.
Obliged.
Obliged.
The grievance of the petitioner pertains to non-disposal of the application for partition submitted by her before the Deputy Commissioner's office in accordance with the Regulation 99 of the Assam Land and Regulation.
Partition.
Yes, application for partition. What has happened was the land.
Will issue notice.
Lordship,
There is a title suit pending.
Lordship,
title
Lordship,
suit
that
is
title
pending,
suit pertains to another plot of land. not the, of course, the entire, originally there was a plot of land measuring 3 kotha 14 lesa. And these particular land, it will,
Treaty for Senate Council for petition who is aggrieved by inaction of the respondent authority in passing appropriate orders in an application for partition of land. The petitioner claims to be the owner in possession of a plot of land measuring 1 kotha 3 lesa out of a larger plot belonging to her maternal grandfather.
no, paternal.
Maternal grandfather. It is further submitted that though a civil suit is pending from that does not directly affect the land in question, and there cannot be an impediment in passing appropriate orders of partition. That notice is issued written by 4 weeks. Revenue Department and Port Law 1 has Burwa 2 and 3 extra copies by tomorrow.
Please, Your Lordship. Lordship, what has happened in this case is that there is one school named Koyakusi Milon High School, which was established in the year 1984 by the SMC in village Koyakusi Pam. And later on, Lordship, that school was being provincialized by the government of Assam in the year 2011. But unfortunately, Lordship, in the month of August 2019, the respondent number 6, that is the headmaster of that particular school, and the SMC respondent number 7, they have illegally occupied my land, my plot of land, where I am the recorded pattadar of that plot of land, which is located in Koyakusi Gaon, in the same district of Borpeta, Lordship. And I am the recorded patta holder of that particular plot of land. And without any failure, Lordship, I have been paying the land revenues, which I have annexed, Lordship, as Annexure 1. That is in page 10. Lordship may kindly peruse.
Have you initiated a proceeding under the Land Grabbing Act?
Lordship?
Have you initiated a proceeding under the Land Grabbing Act?
No, Lordship. Lordship, I have submitted my representations to respondent number 3, 4, and 5 regarding my grievance, Lordship.
No, can we adjudicate into matters of this nature? You have a remedy under the Land Grabbing Act. If you say that the land is a pasture land belonging to you,
yes,
and the land has been occupied illegally by somebody,
yes,
you file an application under the Land Grabbing Act.
Lordship, sure, but my fundamental rights has been violated, Lordship, by the
Statutory
respondent
provision.
authorities.
That fundamental right is also will come into consideration in the Land Grabbing Act proceeding. It's a special act. You are raising questions of fact. Tomorrow you'll be in difficulty. They may say something else. If something else is said, if there is a dispute on facts, then it will be difficult for us to enter into such dispute.
Lordship,
you may have a case on marriage, but we will not be able to enter into such disputes. You have a proper remedy, efficacious remedy, Land Grabbing Act.
yes,
And otherwise also, it's a civil dispute. Your land has been encroached by the civil suit. How can you come to writ court?
Lordship, may kindly peruse page 16, Lordship. We have also filed an RTI application,
Yes.
where in reply it has been mentioned clearly that the said school has other land in different school. The vernacular is on page 18, Lordship.
Madam, we are not disputing what you are saying on fact.
Yes, Lordship.
Now your land has been encroached by somebody. You have remedies in law. How do you come to writ court?
At this stage, notice may be issued, Lordship.
Notice issuing is not a routine matter, madam. You have to make out a case.
Lord.
Come before this court to issue notice. Don't expect that from this court. This is essentially a civil dispute. Yes.
Yes, Lordship, it is a civil dispute and they may before the civil judge.
You take instruction to we are not discussing today. We'll discuss on the next day. We have it for motion. What is your name?
S. Yasmin.
S?
Yasmin.
You're not yet on record.
No, Lordship. I'm on behalf of Mr. S.H. Sikdar.
But that's not appearing on instruction of the S.H. The advance of the petition is encroachment of his battalion in village Koyakuchi Gaon, Musa, Paka PK, in the district of Bourbon. Case of the petition that the private respondents have encroached upon the land of the petition, and the petitioner has also submitted representation which have not been acted upon. I must ask Guru that State Council, however, submit that the dispute raised is essentially civil in nature, for which remedies in law are available to the petitioner, either to file a civil suit or to take record of the Assam Land Grabbing Act with the decision of that instruction by the London State Council, and the matter be listed for motion change on 4th of December. That extra copy, get an extra copy of the written served on Ms. Barua by the court during the court.
I am for 3 and 5, Lord. I am for 3 and 5.
They have just said private official response. They are not issued.
Obliged.
Wait, please, Your Lordship. Sir, repetition has been filed, alleging the illegal harassment meted out by the respondent number 6, more particularly, in a guise of an inquiry and investigation, and issuing the impugn notice in XRL. For there's a 41A notice has been issued to him, and later on 5/11 this month, Your Lordship, another 41A notice has been issued. This notices has been issued in the without the territorial jurisdiction of the police officials, more particularly respondent number 6. Though the petitioner has granted the absolute interim protection, Your Lordship, on 8/8/2008. Already 161 statement has been already been recorded.
Where page?
Lordships?
Page.
Annexure
72.
72, Your Honor, 69. And operating portion is 70. Now, the entire facts of the investigation has been looked after by the respondent number 6, respondent number 5, the Jorhat police case. Now, the respondent number 6 has came, which is not in the territorial jurisdiction of this entire police station, Your Honor. It is a Morini police station. He has issued unauthorizedly, without any reasons, directing us to the petitioner to appear before him, harassing him on multiple ways by telephoning him.
Where is that page?
That is, the annexure is page 72, Your Honor, annexure L.
72 is by Morini.
Is a Morini. Already the investigation has been looked after by the Jorhat police station by respondent number 5.
This is by Jorhat only.
Jorhat only. Now, why the respondent number 6?
Where is the notice?
Page number 72, annexure L.
That's by Jorhat.
You know?
72 is by Jorhat only.
No, down below it is signed and signature by the circle inspector Morini Circle in the under the police Morini police station. Now, more particularly, if you can go to 73, page number 73,
yeah.
It is a corrected whimsically, Your Honor. '73 is this is a type copy. 72.
Where is the question of harassment? You have been called to the police station. You are on interim bail. What's the difficulty in going?
Now the entire case has been looked after by the respondent number 5. That is the Jorhat police station.
Yes.
And Morini case has not been Now the perusing of the MPO notice, your lordships, the Morini police station has called for the Jorhat police station. That means this Lotus Hill police station call the Morini police station. That is one of the factor. This respondent number 6 has no way authority to issue the 41 notice. Now, more particularly, the Ernest Kumar's judgment has said that the issue of 41A notice should be furnished to the petitioner or accused person within a period of 2 weeks after lodging of the impugn FIR. Now, the complaint has been lodged in 2016.
Your presence cannot be secured by the investigation agency.
Lordship?
Your presence cannot be secured. You are not required to be present for them.
No, I have already appeared before the respondent number 5, which is a Jorhat Police Station IO, investigation officer. Now, already has been completed. In terms of the
What has been completed? This investigation is over.
No, the investigation has been under the domain of the respondent number 5. And on the count 161 statement, this honorable court has passed the interim order absolute, Your Honor. Now, after a month later on, the respondent number 6, the Morini police station.
Where is the interim order?
Absolute,
made absolute.
The absolute is page number 69, Annexure J.
69.
The operating person
Petition shall not hamper. Petition directly
on perusal of the material so far collected. This court is considered opinion that this custodial interrogation of the accused petitioner is necessary in the present case. Accordingly, interim order dated 31/5/2003 is hereby made absolute with the following conditions. Now, the investigation has under the domain of the respondent number 5, that is the Jorhat police station. Now, Morioni police station, in lieu of
Morioni will not come on. It does not come under Jorhat.
Yes, that is why.
Doesn't come.
Doesn't come. Now, respondent number 5 has still investigated the process. Now, why the
yes? Why Morini is? How is Morini concerned?
Lordship, in this regard, I have to take instruction that he is for investigation of the PS case number 929/16. He is required to investigate and send this notice.
It is an investigation of the Jorhat police station, and Jorhat police station has been IO is the respondent number 5.
Here in the notice and page number 72.
But your appearance has been directed to be at Jorhat police station.
Yes.
Not at Morini.
No, not a Morini case. Now, why the Morini police station has reluctant in forcing me to appear at Morini police station?
No, not Morini police station. Hence, you are directed to appear before me.
Appear before me.
Jorhat police station.
Yes. Me means that is Morini police station.
No,
Jorhat police station.
No. The circle inspector has been under the jurisdiction of Morini police station.
Doesn't matter, but it's written Jorhat police station is corrected. Come to 73. You have to appear in Jorhat only.
That is why that you are directed to appear before me on positively at Jorhat police station, Guwahati. But the issue has not been under the domain of the Morini police station. Now, though already the IO respondent number 5 has been allotted to the entire facts of the matter, and MS Kakumoni Sankakoti, he is the IO. She is the IO. Kakumoni Chitrakar. She is the IO of the entire matter. Kindly go to
the last line of the notice, Lordship, page 72. Hence, you are directed to appear before me on 30/10/23 positively at Jorhat police station.
And that more fully, Your Lordships, that.
Madam, why are you using the stationery of Guwahati?
Yes.
Because
this is typographical.
Not typographical.
It is not typographical.
See the original at page 73. It is Dispur PS station.
It is corrected.
Then you erase dispute, write Jorhat. Thereafter, Guwahati still remains.
Guwahati remains.
Why?
Typographical error.
There is no typographical error.
No. Why are you using the stationery of Dispur?
Yes, Lordship.
This 41A notice is of Dispur police station.
Now?
Confusion is there, Lordship.
You take instruction.
No,
Part 3H, then it comes.
Till then, this MP notice may be stayed, Your Honor. I may be anytime picked up, Your Honor, and dragged to the police station, Your Honor.
When it comes to the petition,
I will bring instructions.
the petitioner is an accused in
Johar PS case.
Jorhat PS case 9/29 of 2016, which was out 2016. The petitioner who had apprehended arrest the state case after a long period of around 6 years
7 years almost.
had approached this court with an application for anticipatory bail under section 438 of the CRP, and this court in the state application registered as AB 1868 of 2020 had passed an order at 8/8/20 by allowing the application, and the interim order at 31/5/2020 was made absolute. Also, the specific grievance of the petition is that while the case has been registered in the Jorhat case, in which the petitioner was also examined and his statement recorded under section 161 CRP, he has been served with a notice issued by respondent number
6,
who is Circle Inspector Morioni Circle. Also, it is submitted that the state respondent number 6 does not have any jurisdiction to issue the impugn notice under section 41A of CRP. Also, the learned counsel has also referred to consequential communication dated 5/11/2020 by the Dispur police station, by which the action taken by the responsible six has been informed to Sapera. This court has noticed that the impugn notice under section 41A of the CRP has been issued to the petitioner in the stationary man for Dispur PS by making certain incomplete correction by hand. Also, see that is incomplete. That notice be issued written on 11th of December 2023. Also, that step be taken for service of notice on the respondent. No, no. As Burwa, that is state council accepts notice on behalf of respondent 1, 2, and 4.
3 and 4.
Not 3. 1, 2, and 4.
1, 2.
1, 2, and 4. That extra copies. Except for service of this upon respondent 3, 5, and 6 be taken by registered post by tomorrow. Para 3. Burwa, learned council. Based for interim order. Para considering the facts circumstances and second, court is of the prime minister that the impute action does not appear to have the sanction of law. According to the impute notice dated
After this notice, one more
impute
notice has
notice
been
dated 27/10/2023 and all further action direct appearance of the petition at the instance of the circle inspector, Muriani Circle, shall remain suspended.
Deeply obliged.
May I
Deeply
please,
obliged.
Lordship, one another notice has been provided to him on 5/11/20.
And subsequent notice.
Subsequent notice.
This is by dispute, madam. It is only a communication of the earlier order.
Yes,
We have
sir.
said all subsequent orders.
Deeply obliged.
My lord, I would like to take some instruction, my lord. Matter may be adjourned, my lord.
What's the matter?
Matter, my lord, my village is situated nearby the Karimganj town, having the small red soil rocks, my lord, cemetery areas. However, my lord, some unidentified persons were cutting these lands, my lord. Cutting these lands and selling the soils, man, for which the schools, the dwellers, the villagers, the roads,
Let him take instruction. What instructions do you want to have?
whether, my lord, the inquiry has been initiated or not, my lord. Let them take some instruction from them, my lord.
Lordship, just one point we have. His locus is a bit questionable because he has not contended how he is affected personally.
I am the villagers.
Perhaps some land records or anything should have
The
been out
villagers
picture.
notice. So who are you? One person or many
I
people?
am the villagers, my lord.
How many of you?
I am the villagers, I am single persons, my lord. So, page,
You
para
are
number,
a villager. Yes. How? Where do you stay?
my,
From.
yes, my lord. I am para number 2, my lord.
From. Where is the action taking place?
Maizram, I am from this village, my lord.
What is your prayer?
Here, my lord, page 7, my lord.
This soil extraction, this matters whether those are given by way of some jail notice. How do you straight away come and challenge those? And the question of your locus will definitely come.
I am the villagers, my lord. I am directly affected by this act of the respondent, my lord.
Where is your land situated?
My land situated in the Maizgram area, my lord.
How much land?
My lord, this is not my, this is my personal land. The land of the whole villagers.
How
my
can you come up with a writ petition? Why not here? Has the village given you the authority to represent them?
Yes, my lord. I have filed a representation before this.
Has the village given you authority that you are the main person? Are you the village headman?
Orally, they have given, my lord.
You are the village headman.
I am not a
Gaambura.
village headman.
Gaambura.
No, my lord.
Then
I am the villagers, my lord.
what capacity?
Where, my lord, I have given the violation of Rule 7 of some minor.
Why should we adjudicate a violation, alleged violation, at the instance of somebody who is nowhere connected?
My lord, I am being a villager, my lord. I am affected, my lord. Being a villagers of this.
Where is you stated? What is the nature of the effect you are facing?
My lord, para number 5, my lord.
Yes.
That the village is having schools, human dwelling, RCC houses, bridge and roads due to cutting of soil in violation of existing rules, causing severe disturbances of local people and their lives becomes endangered.
How? What are the instances? Why your life has become your is affected? What is the nature of disturbance?
Disturbance, my lord. My lord, may I read my para number 6, my lord, 7, 8, my lord. This is the petitioner begs to the at present it is noticed that some identified person disturb the natural habitats of wildlife. Their dwelling house is destroyed and many animal species are
Yes,
losing.
what have you done till now for the society, for the wildlife? What social steps have you taken?
Question, my lord, the whole villagers have been affected due to
What
this.
have you taken till now? What steps have you taken for protection of the wildlife
My lord,
till now?
by executing the rule 7 of the concession.
What is your role till now? What is your age? What do you do?
I have filed representation, my lord.
What is your age? 44 years. What do you do? What is your profession?
Profession, not a government servant, my lord.
What do you do?
I am the local businessman, my lord.
Business, what kind of business? What kind of business? You are concerned about sustainable development and existence of the village. What have you done till now? You are a social activist.
You my local person, my lord.
What have you done as a social activist for the village?
In many things, my lord, for the villages, my lord, being a conscious person of this.
What have you done till now?
Till now, I have filed this in this case, my lord. In this matter, I have filed a representation. My
No, earlier to this, you are a social activist. What are your social activities?
My lord, for the villages, sometimes, my lord, the village problems we have.
Where have you stated? What have you done?
There is no official records, my lord.
Official records. You produce it.
There is
Till now, what have you done for the village? You are a social activist. You are working for sustainable development. What steps have you taken for sustainable development for the village? What is your qualification? Chaudhary, what is the qualification of the petitioner?
That, my lord, I have not annexed any document.
Or H.R. Chaudhary Learned Counsel for the petitioner. The petitioner submits that he is one of the villagers of Maijgram Gaon Panchayat in the district of Karimganj and has approached this court by alleging that there is massive cutting of tilas and deforestation for which the villagers are being adversely affected. Also, Sri Ishan Potter, Learned Counsel Executive for the Forest Department, however, submits that the present petition is not in the nature of a PIL, and the locus of the petitioner is also questionable. In paragraph 2 of the petition, the petitioner has stated that he is concerned about sustainable development and existence of the village and is also a social activist. No other details have been given in the petition. Full stop. The petitioner is required to file additional affidavit, putting on record the steps taken by him as a concerned villager and also the occupation profession with which he is engaged. List after 2 weeks.
Bless me.
Well, by taking sale permission in the year 98, my lord, I purchased a plot of land. It was mutated, my lord.
Where?
Yes, my lord.
Where?
Bongaigaon district, my lord.
Okay.
Thereafter, it was also mutated, but subsequently behind my back, my lord, in the year 99, it has become fast, my lord. Secondly, my lord, I have filed case, my lord, one after another, but government wrongly filed affidavit in opposition in earlier case, my lord. But subsequently, they have again, my lord, revert saying that, my lord, it was by mistake, it was filed, but it has been become, my lord, already fast, my lord, because of the letter of the Commissioner Secretary in the year 2000, my lord. Kindly peruse your lordship first of all, my lord.
Mr. Das, you are challenging a communication of 1999.
99, my lord. Already there is a similar order, my lord, from this honorable court. It was passed by.
Page.
I have not annexed here, my lord. I have marked here, my lord. Last portion.
The aspect of delay was not looked into.
Yes, my lord. Lordship?
Aspect of delay was not looked into by the court. The delay aspect was not looked into by the court.
Oh, no, my lord. Because, my lord, earlier there was another proceeding, my lord. Writ petition was earlier also filed, my lord. I filed writ petition in the year 2015, my lord. In this case, my lord, they have filed.
Why you take not notice? He is relying upon an earlier similar order. So you take instructions, we will try to dispose it. Or we age the learned house for the petitioner claims to have purchased a plot of land in the year 1988. 98 by taking
sale permission.
Due sale permission. Plot of land at in village of Highpur in the district of Point by taking due sale permission. Consequently, the land was muted in favor of the petition.
611.
However, due to some mistake on the part of respondent authority, the mutation was erroneously cancelled, for which the petitioner has approached this court as representation are also not acceptable. It does something that so far as position can there is no dispute the fact that is internet also has also placed put an order past W45 by a similar manner.
Same cell deal.
In a matter, in an identical matter concerning the same thing.
Yes, my lord. Same day cell deal.
It appears that the matter can also at the motion stage itself. However, before such disposal, it would be prudent to give the United States an opportunity to have to examine case project. Full stop. Sarah? According to this court is on 6th of December. That an extra copy
And
of the decision served upon as per the State Council, along with a copy of similar order passed as mentioned above during the course of.
All right.
Do you have an extra copy of this order?
Yes, my lord, I have.
You have. Make a copy and deliver.
Indeed.
Come up, 5 minutes.
Wait, please.
70.
Wait, please, my lord. Name is reflected in the list.
17 is there.
Yes, my matter is not.
You're not there.
Yes, my name is not reflected in the cause list.
What is it?
One of the matter relates to family pension being demanded by another lady who is not the wife of the deceased husband. The petitioner is still living in the railway quarters, who is the first
What is
wife.
your cause of action?
My lord,
What is your grievance?
my demand is for an FSL report, my lord.
Now, what is your grievance?
Oh, grievance, my lord. He is the first wife. He has been living in that house. But one second, some lady, he has come and lodged an FIR against that lady. She has lodged an FIR stating that some other lady has come with the demand of the family declaration. Annexure A, my lord, page 21. The whole FIR is there. Then the matter went even till there was a title suit, and so many things happened, but we haven't reflected all those. Just first FIR is of the petitioner in annexure A 21, and the next one is the CGM's order, which reflects, yes, the case has prima facie. It reflects that there should be a second final report. We are against the final report, which is submitted very whimsically and without doing any of the police has
Against
got some
final
nexus.
report, you have the images in law.
Yes, but my lord,
You filed your
we are-
objection.
but
Has
we
it
have
been
filed
accepted?
yes, my lord, we have filed an objection. We were before the CGM, Hojai, and the Hojai court has clearly given her order in page 60, my lord, annexure
60.
60, my lord. That is the FIR. CGM Hojai's order.
For a different investigation.
Yes.
Now, what is this case now?
So that is the case that we may be allowed to go for an FSL report because of the signature is absolutely doubtful. It's just mechanically given. That signature doesn't tally or is it
See,
will be
madam,
very clear.
this order is a new one, relatively new one, 11/9/2023.
Yes, my lord.
The Learned CGM
CGM?
accepted your objection and has
Yes.
directed further investigation.
Yes, my lord.
That to by a different investigating officer.
Officer, yes, my lord. That
Now,
is very
in the ambit of his investigation,
Yes.
he can do whatever is required. Where is the scope now of this court to
My lord.
direct that officer what to do, what not to do?
My lord.
Where is your application for FSL?
There's my lord, we have submitted an application, my lord, for FSL before the court. And in our annexure A, my lord, that is page 21, I've submitted the FIR against doubting of the signatures of the dying declaration of the deceased. We are doubting that signature, which is very clear in the
How
first
to do the
final
investigation
report
can
itself.
dictate the IO how to do the investigation.
Yes. Not
Okay,
how to
fine.
do that, not how to do, just give a second chance for that, because there is some nexus which is established because the documents are with the railway authorities. The main fact is that, my lord. There is a title suit. There was a title suit. After the title suit, they came to court, and then title suit is very clear in 164 statement of the petitioner himself, stating that the petitioner is the first wife, and the second one is some employee of railways. It's not clear why she's demanding that and why she's wanting to. Because actually, the main crux is the pensionary benefits, my lord.
Is the scope of going for FSL examination been ruled out, or is it been
not
Rejected.
ruled out exactly, my lord. They are not satisfied with the FSL report, my lord.
No,
So
no. Is the scope of having an FSL examination ruled out by the authorities or rejected?
that ruled out by the authority, meaning the
See,
railway
the
authorities,
first
they
part of
haven't
your
appeared. They just
first
come
part
and
of your
appear, my lord.
prayer doesn't make any sense because there is already a fresh investigation directed
Yes, my lord.
by the latest order of the Learned CJR.
Yeah, for another FSL, my lord, for another fire report, I think. It's very much a different investigating officer,
Yes.
if possible, who shall again examine the informant and other witnesses.
So your grievance appears to have been redressed to a substantial extent by this order at page 60, 11/9/2023
Yes,
order.
we came before this court only after this order, my lord, with the strength that, okay, the CGM is satisfied with our submissions and they have come to know that there is something, otherwise the petitioner would not have gone to this extent of doing the
No,
investigation.
that is exactly what we're trying to expect from you.
My lord,
See,
this is
your
simple.
grievance has been
Yes, my lord.
substantially redressed by 11/9/2023, wherein investigation has been directed, further investigation.
Investigation and other witnesses who are aware of the allegation.
Now,
Why they are doubting the
where is
signature?
where are the metrics to show that the scope of making an examination of FSL has been ruled out or rejected? Is there any order?
There is no order. No,
Then why
no
have you
order.
come to this court?
My lord, seeking at least a notice that the railways come and
No,
tell
no,
us
why?
about the-
Is that scope has been that scope has not been ruled out? Mr. Borwa, what do you say?
the notice can be issued, my lord, that the railways come.
Lordship, I rightly had, because the scope is very limited. Here, nothing going beyond that order. Already investigation.
See, that order has substantially redressed
Yes.
the grievance of the petitioner. Petitioner alleged that the final report could not have been submitted. So, an objection of the petitioner has been accepted, and further investigation has been directed.
Yes.
And that too
Once
by
the
an
final
independent,
report-
by another investigative
Yes.
officer. Now, thereafter, where is the scope now?
There is no scope. Already that part of the remedy has been exhausted.
You take instructions.
Can we ask
And in fact, if we Lordship goes to the prayer portion also, that prayer is also very limited as regards
yes, well,
that
we
investigation
haven't
part.
done.
So investigation
Just the
not being
investigation.
satisfied. So they
Can just a notice be issued to the railway authorities, my lord.
Railways is the party.
Railway part excellent.
Railway is not even a
Railway
party,
is not a
madam.
party.
Oh, not the party.
So your
This
actual
is the difference.
actual
Railways-
grievance will still be unredressed.
You see, I was, my name is not shown in the causes with the reason, and this I accepted because I was in the case from the beginning. That is the reason I accepted the case. I have to submit whatever I have. My lord,
Those are something very
I may
internal.
be allowed to file an IA along with my Vakalatam. I don't know what they have done.
So, Wakalatama, we may not
Money,
insist
no,
if you are
but
having somebody
okay,
on
and-
record.
yes.
We may not be
My lord,
very
may
strict with this purpose.
allow me to file an IA
Okay.
showing the
After
notice
hearing
for railway part.
I must be seen alternate counts. I must be seen alternate counts submit that she would appear for the petitioner in case, though she had not officially signed the Wakalatama.
Yes.
To compare. Alternate counts have please that 2 weeks time to file IA
I deeply obliged.
to bring on record such relevant information. Relevant fact.
Deeply obliged.
May I please your lordship? Lordship, this matter is regarding no confidence motion against the petitioner, my lord. No confidence motion was passed, my lord, in violation of section 15 and section 17(3) of the Assam Panchayat Act, my lord. Imping notice is on, my lord, page 14, my lord. 14, my lord. This was given to the, my lord, the block development officer, my lord. And block development officer issued the impugn notice, my lord, on page 16, my lord. This notice was issued on, my lord, 2/11/2023, my lord, and I received this notice, my lord, on 4/11/2023, my lord. And
But your tenure is coming to an end, I think December. How many days?
Lordship, earlier I approached this honorable court, my lord, Annexer 23, my lord.
Page?
Page 23, my lord.
26 is the reading.
Now, when is the tenure come to an end?
Lordship.
When is the tenure, 5 years tenure come to an end? When did you take charge? Last part of 18, isn't it?
18, my lord. Last.
So, for 5 years, when is it coming to an end? Do you get anything in this?
Because record is necessary.
Today is what?
22nd.
22nd.
Yes, ma'am.
This resolution is dated what? 6/11. 6/11.
Yes, madam.
Even if we issue notice, what will you get? Practically, you will not get anything.
Lordship, impugn minutes is on page, my lord.
Mr. Laskar.
Page 18, my lord.
Mr. Laskar, even if
This
you
was
make,
not given effect till date, my lord.
this is 6/11. How can we say this?
Deemed to be vacated.
Who's running the show now? Who's running
I
the
don't
show?
have instruction, but deemed to be vacated, my lord.
This 6/11.
As President
This is
is
not
the
given effect, my lord, as per my
Issue
knowledge.
notice.
no?
Heard
notice my comment.
this, heard 3/8 Laskar.
Yes, my lord.
When it comes for petition, put the para. The petitioner was the president of 5 number 5 NO. Paloi Chera, Des Sultani Chera, Panchayat of South Hailakandi Development Block. The petitioner is aggrieved by a no confidence motion held on 6/11/2020. The ground of challenge, amongst others, relate to violation of the provisions laid down in section 15 and 7 of the Assam Panchayat Act 1994. It is the case of the petitioner that no notices were issued to her and notice was issued to Block Development Officer, which is in violation of the procedure laid down, which are mandatory in nature. That notice be issued, returnable on, will give a date. Returnable on when?
My lord.
Can we have it on
After 11th, any date?
on 11th?
12, my 12.
12 is Tuesday.
Then
13th.
13.
But he'll hardly have any days. Can it be on 8th?
I can try, my lord.
8th.
Yes, my lord.
Will you,
Notice is good.
are you able to serve Dusty?
Yes, my lord.
Try Dusty on 8th. Huh?
8.
3. As Dr. Standing Council, Panchayat and Rural Development Department accepts notice on behalf of number 1,
1, 3, and 5.
1, 3, and 5. As Burwa, by the State Council for respondent 2, 2, and
Yes.
2, only 2. That extra copy of the written can be served upon the laptop during the course of the day. Tests have to be taken for service of notice. Upon the respond numbers 4, 3 or 2,
4 and 6 to 14.
4, 4, 6, 3 or 2, 14. By registered post daily, shall by tomorrow. Trustee, will you serve trustee? Petitioner Dilana Kong also prays for liberty to cause justice service. Liberty is granted, and such justice service is required to be routed through the registry of this court, and the notice accompanying the justice service would clearly reflect the next date fixed, that is 8/12/2023. The petitioner is also required to file affidavit for the next date as proof of such justice.
Lordship, till then status quo may be maintained.
Already seem to be vacated, my lord.
It is
He
not
already
given
out of
effect
the
to date,
post,
my lord.
out of the chairman.
Only at least my status quo may be
The status quo will hamper the process, my lord.
Who's are you holding the post of
Yes, yes, my
No,
lord.
my lord.
Yes, my lord. I am.
How can he see, my lord?
No confidence is passed against me, my lord. My notes is not given effect till date, my lord.
No, if you are outside from the office,
No, my lord. No, my lord. Not outside, my lord.
in spite of the no confidence,
No, my lord. There was no
then why have you challenged?
order was issued, my lord.
You continue sitting.
Still,
If you
status quo
have
may
been
not
given
be
effect,
maintained,
why
my
have
lord.
you come to the court? There is no cause of action. Let them pass for orders
This-
on papers.
Lordship, this minor.
The United Council prays for an order, prays for an order. Considering that the matter pertains to no conflict, prayer for an order.
Obliging.
Mardika SI akan yes but expressio.
My lord.
Mr. Akand is specializing in expressio matters. Whenever he appears, it's expressio matters. Okay. Another case. Another case for the petitioner called so a mention was made on regarding facilitating hearing by this video conference. There is no endeavor in that regard. The matter is called up. It is the administrator. The next. Yes, what is this?
Matter relating to my lord, 3 laborers dying in a reservoir, my lord, find they are working, my lord, they died due to lack of oxygen and hot weather, my lord. In the earlier occasion, my lord, your lordship has issued notice on a matter arising out of same incident, my lord. WC 666-9 of 23, my lord. My lord. And the FIR at best 26.
Did you appear in the earlier matter?
Yes, my lord.
We to notice it. But the question of maintainability will be
The
keeping open.
question of maintainability does not arise, my lord, since there is a similarly situated.
We have shown the Upahar Treasury.
What tragedy also, my lord, in fresh writ petition was filed before the High Court, my lord. Thereafter, the appeal was filed by the respondent before the Supreme Court, my lord.
Was it a writ petition?
Yes, my lord. What tragedy also, my lord, writ petition was filed, my lord.
Petition notice it. Or
this is the part tragedy. Paragraph 5, 11, and 24, my lord.
Not comes for the petition. Paragraph?
Paragraph 5, my lord. Page, my lord. 506. The association filed a writ petition before the Delhi High Court. Paragraph 5. 1, 2, 3, 4, 5. Line number 5. Thereafter, my lord, the decision, my lord, paragraph 11.
For the petition. The petitioners are the wife and mother of one side applicant who had met with an accidental death on 25/7/2020 while working in an underground water reservoir in the district of Dhubri as a part of implementation of Pakira Nidhar pipe water supply scheme under Dhubri division for retrofitting under the program. It is submitted that Bilasipura PS case number 26 of 2020 under section 304 IPC has also been registered. The petitioner have claimed compensation by means of filing this petition. Three, appearing for department, however, raises the issue of maintainability of this petition by contending that the claim is for compensation for which there is no yardstick laid down in law and would require adducing of evidence even in case even assuming that a case is made out. In reply, 3, who says the learned counsel for the petitioner has submitted that this court would be competent to adjudicate the issue as there are precedents to support the petition for the parent. That notice the issue returnable. He further submit that arising out of the same axis, another writ petition has been filed in which notices have been issued. The same being WPC
666 of 2009 of 2023.
66669. 6669 of that notice the issue returnable by 4 weeks. 3, Kota Court, the learned counsel accepts notice on you have record for? No. And go to like Revenue Department 1, Finance, RM, Purva. For response number 2, for Sri Bothapur for 3,
6, 7, and 8,
3, 6, 7, and 8.
and 9, Lord.
What about 5? 3, 6, 7, 8, and 9. Jal Jeevan?
Lordship,
I think-
normally we do not appear for missions unless they.
Jal Jeevan, government, okay. Jal Jeevan? Five only. So it will be for 3, 5, 6,
7,
7, 8, and 9. As Guru for 4. That extra copy out of the respondent by tomorrow. Steps for service of notice of the respondent 10, 11, 10 and 11. No, you are not only for 4, you are for 4, 12 and 13.
12, 13 also.
As Guru for 4, 12, 13.
Oh, Ajay.
You should make the parties in accordance with the confidence. You enter private respondents in.
Actually, there is a mistake, my lord. We have not made party 12 and 13. After serving copy, we have 10, my lord. Accordingly, we
Newly
arrange the. We
12,
arrange the.
12, 13.
Yes, my lord, that is
10 and 11 very settled itself by tomorrow. Please along with WPC 6669 of 2020.
obliged.
You take this back.
My lord.
May please, your Lordship.
Yes.
Your Lordship has already gone through the matter, my lord. So multiple direction by multiple statutory authorities, my lord, which put the petitioner in an, my lord, incongruent obligation to multiple authorities, my lord. So what happened in this case? Two of the bank accounts, my lord, they are involved in money laundering and economic offences cases, my lord. So accordingly, respondent number 3 to 6, they have issued notice to the petitioner seeking information regarding the bank account, as well as, my lord, by petition number annexer 7 and 8, they have directed us to freeze the bank account of that particular two accounts, my lord.
That's number 7 and 8.
Yes, my lord. Just annexer number 7 and 8 at page number 39 and 41.
Yes. Now what's your
Now, but thereafter, respondent number 1, the enforcement directorate, they have also directed us to put the bank account under freeze, debit freeze. Accordingly, my lord, we did. So respondent number 1 to 6, they have directed us to put the account under freeze, which we have accordingly did. Now, my lord, the adjudicating authority under the Prevention of Money Laundering Act, they have passed order on 26/9/2023, thereby confirming the order passed by the Enforcement Directorate. Yes, 21st of April. So after passing of that order, 26/9, the Enforcement Directorate has directed us to issue demand draft in their favor without lifting a ban of the freeze account by the other respondent. So if we follow the instruction of the ED, it will amount to violation of the direction issued by the other authorities. Accordingly, we wrote letter both to the Enforcement Directorate.
Why did you
If I may, Lordship. Lordship, in any case.
I think you can settle this matter.
No, it can be settled right now, Lordship. No, in fact, after the matter being referred to the
PMLA.
no, to the adjudicating authority under Section 8, once the provisional attachment has been filed, Now, what has to be done? The attached account, whatever is there, goes to the government for the time being. And the agencies which are there, Lordship, the government agencies which are there, Lordship, these are all under the central government.
Correct.
These are all under the central government. In any case, if the money is remitted to the ED, he can always produce that order before the other concerned authority. And in that particular aspect, Lordship, there is a order of the Karnataka High Court. Similar as there, the bank had already given.
Sir, I think you file an affidavit. Based on that, we'll close this.
Yes,
Without there be an affidavit, we do not want the bank to be in any conflict.
That should not.
You just may clarify that since central government is concerned, whether it is under the ED or under PMLA, the bank should not be at difficulty.
Yes, yes.
Till then, my lord, the operation of the impugned order may kindly be stated.
No,
No, they are not insist upon any coercive action.
I give a statement
No,
because it's
Mr. Das will say that they will not take any coercive action. We are awaiting the written instructions or it is formal.
Till then, no coercive action against the bank, my lord.
Third, he does count for petition bank. It is submitted that two accounts ended. Why have you filed here? Why have you filed here in Guwahati?
Because, my lord, it was issued by the ED Rajgor Guwahati, my lord.
No, the accounts was in Haryana.
Yes. Yes. But it was directed to be paid in Guwahati, payable in Guwahati.
this inquiry was conducted from here.
That two accounts are maintained in the petitioner bank where subject matter of investigation under the PMLA Act, in which orders of debit freeze are in operation, and the same has also been confirmed by the adjudicating authority under Section 8.
Yes.
Under Section 8 of the said Act. The predicament expressed by the petitioner bank is that in spite of such orders of debit freeze, there is a direction by the enforcement directorate for debiting the certain amount from the account, which according to the petitioner would constitute violation of the direction passed in the PMLA procedure. Shri R.K.D. Chaudhary, Learned Deputy HGI, appearing for the responsible 1 and 2, has however submitted that there is no conflict of interest as the objective of both the enforcement director in issuing the impugned direction as well as that of the proceedings under the PMLA is under the central government and is a common objective. Be that as it may, this court is of the opinion that the instructions that the submissions made by the learned DHGI be placed on record by way of an affidavit based upon which the petition itself can be disposed of without going in marriage. That is matter for motion.
On
Again,
29th or 30th, Lordship. So that
when on 4th of December, Monday, they took it.
That's right.
Whenever you say,
I can do it next week also.
so 11th on then 4th of December.
Not on first, Lordship.
Fourth.
Let it be on
Fourth of
Let it be,
September.
yes.
Fourth of
Before that, I will find.
for to enable filing of such affidavit opposition affidavit. Sarah? Balancing the equities combined is directed that till the next date no course of action be taken against petitioner bank pertaining to present issue.
I'm obliged.
Recovery certificate was issued on 2019 against the petitioner and others for rupees 1 crore 70 lakh.
What is this?
Recovery certificate was issued against the petitioner for an amount of rupees 1 crore 70 lakh. Then thereafter, your lordship will kindly see page 35. Page 35. Because my whole case is, my lord, they are selling the property undervalued. Page 35, your lordship will kindly see. This is the certificate issued in the year August 23. My lord, CHBI is directed to take following steps and file report on the next day. Publish the sale notice within 4/9/23. Affix a copy of the proclamation of sale on the conspicuous part of the properties. We have said this has not been done. Serve proclamation of sale upon all CDs by speed post on 4/9/23. Forward a copy of the proclamation of sale along with a copy of the base order. Now your lordship will kindly see rule 8.4, my lord. Rule 8.5. The Securities Interest Enforcement Rules 2002. Now, rule 8.5, my lord. Sub rule 5, rule 8.
You are referring to 2002 rule.
Yes, ma'am. Illegal.
Security interest enforcement rule.
Yes, ma'am.
8.2.
8.5, ma'am.
8.5.
Report that.
That's for affecting.
Yes.
For affecting.
8.5, yes. Before effecting sale of the immovable property referred to in sub rule 1 of rule 9, the authorized officer shall obtain valuation of the property from an approved valuer and in consultation with the secured creditor, fix the reserve price of the property and may sell the whole or any part of such immovable. This has not been done. Now, next, matter 6, your lordship will kindly see. The authorized officer shall serve to the borrower a notice of 30 days for sale of the immovable secured asset. This has also not been. So, if whole purpose is, ultimately, they say, my lord, the total amount is 2 crores. You pay, they have sold it to private respondent. I am saying it is undervalued. I am going to pay the amount within a period of 3-4 days, whatever your lordship says, because paternal property, I want to preserve it, my lord. And all these opportunities, had it been given, my lord, earlier, I could have, my lord, paid them off.
What is the present stage?
Present stage is, my lord,
I
am just protected by 2014 5 SCC 660. My lord, your present stage is, my lord, they have sold the property to private respondents at 2 crores. And this amount, my lord, I'll pay it within a period of 3-4 days. And whatever expenses.
Now you have said that they have already sold the property.
Yeah, they sold it.
Now where is the scope now?
Scope is there, my lord, your lordship. If they sell the property undervalued and in violation of the provisions of rule
No,
8.4.
we are not saying that we will not adjudicate or will not entertain. But scope of passing any effective order today without hearing the third party.
2000.
Who's right?
I'm not saying anything, my lord. Your lordship will say, my lord, what If I can take your lordship for
No, no, what kind of order,
14.5
no,
basis.
what kind of order
Today,
are
order.
you
Today
expecting?
status quo order, and your lordship will direct me to pay an amount of rupees, same amount of money which has been bought, 2 crores something, that amount, my lord, in the bank or in the DNP within a period of 3-4 days.
How can we barge into the rights which have accrued to a third party?
No, it can be done.
Has also been issued,
If it has been violated, my lord, under value property. This has not been valued properly.
This is your allegation. Without an adjudication of the allegation, without
No,
getting them.
they will bring. So therefore, don't go further. I'm protecting my right. Your lordship will kindly take this 2014 5 SCC 660.
No, we can at best say that they do not change the nature character of this property that much. We
Yes,
cannot
yes.
direct
My
anyone
first
over the
submission is that your lordship, the matter may be taken up at 2, your lordship, my senior will take up the matter because your lordship, at morning, your lordship, my senior Mr. M. Sharma has fell down from the stairs of his residence, your lordship. So he's taking some medication today, your lordship. So he will be there at 2, your lordship. The
Okay,
same
we'll have it at 2.
Yes, your lordship. At 2, your lordship.
Fair.
My lord, that 2014 5 SCC, I'll place it, my lord,
At 2, your
for a
lordship.
second one.
At 2, your lordship.
At 2.
At 2. Much obliged.
What is this additional affidavit?
Hello?
What is this
Additional affidavit, I have shown that violation of 8.4, my lord.
The copy of the additional affidavit is also received only on yesterday evening, your lord.
No, the repetition was also filed yesterday morning.
At 2, your lordship.
They should, my lord, ultimately it's a matter of settlement. It can be done by the thing because no opportunities was given to the petitioner for the purpose of payment of the.
No, we do not know how much resistance will be by the third party.
Yes, yes.
If your allegation is correct.
He has already broken his leg, Bala.
No, if your allegation is correct that it is undervalued, then
Yes.
they will resist it.
Yes, yes. Let them resist it, my lord. They have not gone to the valuer. It's a, my lord, an auction was given on the 3 bidders came, and to the 3 bidders, my lord, one of the highest bidder, the property value is valued, my lord, in the year 2014. On the basis of that only they are selling it. And the opportunity should have been given to me. Yes, I'm selling it the property at 2 crores.
Third party has been made the respondent here.
Yes, I made payment.
Private
So we
party
will
is
protect
there,
their rights.
Property is in Guwahati.
It is in Karnataka.
Karnataka.
Karnataka. Well, this man, he has taken a loan of 1 crore 30 lakhs for plantation, and that plantation went, my lord, infected. He got infected, my lord. As a result, my lord, nothing could be done. So the mortgage amount, my lord, he is going to face problem because of the
security was of Karnataka.
Karnataka.
Of loan taken here.
Loan taken in Aizawl.
Aizawl.
Case filed here. Canada Bank. So I am securing the, because the Supreme Court says, my lord, you will have to pay to the purchaser or along with interest back right now within a stipulated time has been given. That I am going to follow because this opportunity was not given to the petitioner earlier. No. The opportunity should have been given to the petitioner. Yes, we are getting this price. What is your say in the matter? 30 days notice. That has not been given to us.
At 2, your lord. Much obliged.
May it please your lordship. Lordship, petitioner has been died due to electrocution. Lordship, after 1 year, one petition on proceeding is going on. Fight WPC number 3291 2021.
Pertaining to the same
Lordship, after 1 year, the FPDCL filed their affidavit and inquiry report, Lordship, after 1 year. Lordship, and I have through this writ petition, I have challenged this inquiry report, Lordship. Inquiry report, Lordship, page 38, Lordship.
38.
Annexer 10, Lordship.
8. Annexer 8.
Oh, Annexer 8, Lordship. Page 38, Lordship.
you're challenging the correctness of this report.
Lordship.
You will issue notice at this stage.
My lord, there is a provision on Electricity Act, my lord. Any party aggrieved by such report has to avail a remedy, my lord, under 162 for the appropriate government. Any party, my lord. If APDC is aggrieved, shifting burden on us, will move the government.
Yeah.
And petitioner is also.
Lordship, appeal also file. Not dispose of my appeal, Lordship.
Page.
Lordship.
Page 40. Yes, 40. Yes.
Appeal, Lordship, page 40.
He has approached 162.
Let us then he has to wait for that. He has approached this court.
No, it was on 1910. You just immediately have to come.
He has to wait.
Lordship, no result has come out. Lordship.
It's not even
My representative, my appeal not dispose of.
It's not even a month.
Lordship.
It is not even a month since filing of the appeal. Don't you think that you are premature? You might get the relief with the appeal.
Who knows? Tide might turn in his favor also.
He might get relief with the appeal.
Yes.
Lordship.
We'll do one thing. We'll have this after a month.
We'll
keep this pen. And till then, you before you heard. Number?
A Wahab.
A Wahab.
Wanu. Our government.
Your husband passed away. Your husband?
Yes, Lordship.
The husband, in the case of the petitioner, that her husband had met with an accidental death by electrocution. With regard to a prayer for compensation, the petitioner had earlier approved this by filing WP 3291 of 2021 and in the state petition
pending.
An inquiry report dated 3/11/2021 was filed, as per which the claim for compensation was declined, challenging the correct of the state inquiry report of the instant petition filed. Both Sri D. Gopal and Standing Council APTCL as well as Sri S. Barua and State Council submit that there is a provision for appeal under Section 160 of the Electricity Act of 2003 and the writ petition in fact revealed that such an appeal was preferred only on 1910 submitted that instead of entering to the matter at this stage from the petition, the hearing of the petition may be deferred to enable the appellate authority to pass necessary orders in the appeal. But the aforesaid submission appears to be reasonable. But in view of the above, please, in view of the Mohammed adjourned after 4 weeks, pendency of the writ cannot be barred for consideration and disposal of the appeal stated to have been filed on 1910. The petitioner is given further liberty to submit a fresh copy of the appeal to the appellate authority to facilitate such consideration.
Your Honor, may permit me to mention item 55 and 56. Yes, I'm with you. So that matter, Your Honor, apparently has been mentioned, but I'm for the respondents in this and we're suffering a stay. I'm for the Competition Commission.
It was mentioned on your behalf.
No, Your Honor. I am for the Competition Commission. I'm for respondent.
We had asked, it was said that it was on
No,
your
no
behalf.
consent has been taken from me.
No. He responded.
I think it was Arida, Your Honor.
This matter, my lord, Mr. T.J. Mohanta was also for the response. He was appearing here. He was
That's
waiting for
correct.
this matter.
He's
No,
leading me in the
no,
matter.
no.
He's
We-
leading me in the matter.
We know about this matter. It was the day before yesterday.
Yes, absolutely, Your Honor.
So that is why when the
I'm not
the
been mentioned
request
by
came, we
me.
had asked whom are you mentioning for? The respondent.
So not sure which respondent is. There's one other respondent, which is Arida. Maybe it is him. 55 and 56. No.
We have a date. We said 1 week.
1 week. A date may be fixed, Your
And
Honor.
there was an interim order.
There's an interim order, Your Honor.
That's why we were more concerned. Interim order is there. If there is a respondent
Exactly.
request, we have a date. Then tell us a date.
Your Honor may consider. What is it? Next Tuesday? 28th, Your Honor. 29th. 30th. 28th, 30th. Yes, yeah. 30th otherwise.
On 30th.
30th. Deeply obliged. Your Honor.
My lord, as your lordship was saying, my lord, that present status, if it can be maintained, and if your lordship directs me to deposit some amount, I can go. And another factor, my lord, there is a provision for appeal. I did not file appeal because my lord, notice was not served to me as per section 30 of Debt Tribunal Act. If they, my lord, do not serve notice, my lord, I cannot go and file appeal. If I file appeal, I'm required to give 50%. There is no problem about that also, my lord. But if your lordship examines this aspect of the matter, I'll just point out, my lord, they are to protect the interest of the, my lord, the person who borrowed the amount. They cannot sell away the property just like that. For the time being, my lord, your lordship will kindly see para 11. Because single judge dismissed the case, matter came before the division bench. Division bench allowed the case. Then thereafter, the purchaser, my lord, went to the apex court and he got an order of dismissal. And para 11, your lordship will kindly see. Page 669.
Yes. Yes.
I'll just, High Court has found the following infirmities in the conduct of the impugn order. This is the division bench. Before bringing the property for sale, white notice dated so and so, fresh valuation of the property from the approved valuer was not obtained by the bank when the property worth crores had to be sold. There was infraction of sub rule 5 of rule 8. 30 days notice, as your lordship was saying, my lord, as required under so and so was not given, thereby committing breach of this mandatory provision as well. These two provisions applies to the petitioner here. According to High Court, publications in Bharati and Marathi language was affected just 1 day prior from receiving from the prospective buyers. However, publications, this I do not know, my lord, to where they are published. As per sale notice, the appellant was required to deposit the entire amount sale consideration within 15 days from the date of confirmation of the sale. In the counter, the bank has stated the appellant has made the payment within the time allowed by the authorized officer. When the sale consideration is rupees 2.16 crores, the bank was required to give details of the payment made by the appellant in order to hold whether the payment was made within the time stipulated in the sale and whether the time was extended by the officer by accepting the reasonable cost shown by the purchaser and whether the purchaser is bona fide purchaser or not. Ultimately, unfortunately, bank has failed to produce this document.
para 12, we may point out at the outset that the opinion of the High Court on the interpretation of section sub-rule 5, 6, and 8 of the rule is flawless. In this behalf, it would be pertinent to mention that there is an imprimatur of this court as an incidental meaning. Identical meaning is assigned to these provisions in so-and-so cases. Well, all these cases are there. 14, your lordship will kindly see. 14 last, my lord, page 670, my lord, last. Therefore, by virtue of the stipulations contained under the provisions of the SURFACE Act, in particularly section 13(8), any sale or transfer of the second secured asset cannot take place without duly informing the borrower of the time. Para, that page 670, my lord.
Yes.
670, that
Thereafter.
13 is there.
The quotation of the earlier.
Yes, quotation of the earlier, my lord. There it says, my lord, para 13, your lordship will kindly. This court in Matthew Varghese case further observed that the provisions contained in subsection 13, section 13(8) of the SURFACE Act 2002 is specifically for the protections of the borrowers, in as much as ownership of the secured assets is a constitutional right vested in the borrowers and protected under Article 300 of the Constitution of India. Now, your lordship may come to para 14 of that quoted judgment. Therefore, by virtue of the stipulations contained under the provisions of the SURFACE Act, in particularly section 13(8), any sale or transfer of a secured asset cannot take place without duly informing the borrower of the time and date of such sale or transfer, in order to enable the borrower to tender the sale dues of the secured creditor with all costs, charges, and expenses, and any such or a transfer effected without complying with the said statutory requirement would be constitutional violation. Now, para 26, your lordship will kindly see. Para 26. Court, learned apex court, my lord, upheld the order passed by the division bench. Then it says, my lord, before we part, it is imperative to mention that the purchaser has paid a sum of rupees 1.86 crores towards purchase of property and 30 lakhs towards movable items to the bank. He has also spent rupees so and so towards registration fee and rupees so and so towards stamp duty. In addition, dues towards municipal tax, sale tax liability, dues of employees so and so has been paid. The total whereof comes to about 49 lakhs. These were the liabilities of the borrower. In this way, total amount of rupees 2.83 crores is paid by the purchaser. He has also discharged municipal tax of rupees so and so. As we have affirmed the order of the High Court setting aside the sale, we grant 2 months' time to the borrower to discharge the entire liability of the bank. So therefore, my lord, what I submit, my lord, your lordship, now the sale deed has not been registered. Sale has been done, but that auction has been done. I propose, my lord, subject to what your lordship, whatever the borrower has, the purchaser has paid, this amount I'm going to pay within a period of 4 or 5 days, either in the bank or High Court or in the debt tribunal. So, and in the meantime, your lordship will see the records, whether the provisions of section 8(4), rule 8, my lord, has been followed, 8(9) followed. This is my humble submission before the court.
Your lordship, the rule 8984 is not applicable in this case because the judgment is relating to the SURFACE Act, whereas the property has been sold under the Recovery of Debt and Bankruptcy Act 1993. And this is the sale certificate, your lord. The judgment is relating to the SURFACE Act, that is rule 8 and 9, where the intervention of any judicious authority is very minimized, only from the extent of 13(4) notice. And in this case, the DRT has initiated under section 25. And in every order, the petitioner himself was present there. And he has not raised a single point objection, right from the attachment to the fixation of the price. And in bid, there are 2 persons. There are 2 bidders. It is not a single-sided thing. And there is no objection in regarding to the valuation also. The valuation report has been given to the petitioner also. Not a single point objection has been filed before the DRT. And besides that, your lordship, I may raise that section 30, subsection 1. There is a provision of alternative efficacious remedy, that is they may file an appeal against any of the order, but not a single order has been challenged by the writ petition at any point of time. All of a sudden, the property was sold on 9/10/2023. This property was sold on 9/10/2023, and today is almost 1.5 months. So, Your Lordship, this petition itself is not maintainable. No relief can be granted because already we have issued the sale certificate that is before Your Lordship, and we have maintained each and every step that is required by schedule of the Income Tax Act. And even Your Lordship, in the order of confirmation, we have written specifically in my order, Your Lordship, that the DRT's order is there. That is when the sale was confirmed. In the first paragraph, the second paragraph, it has been written. No application under Rule 60, 61 and 62 of the second schedule of the Income Tax has been received from any other party. Till date, no objection. All of a sudden, the writ petition has been filed, raising the issues by citing the judgment of the SURFACI Act. It's not at all maintainable, Your Lord. And the judgment of 2015 I have also placed, that is para 23.3. Once availability of alternative remedy is available, I do not think so it is proper to stop the registration or any other process that has been taken legally, Your Lord. Only to that limited extent, Your Lord. This petition is not maintained.
Lord, for filing notice, that section 30, my lord, the notice has to be given to us. This notice has not been given.
Section 30 of what?
Of the Debt Tribunal Act, my lord.
But he says that you are present.
No.
Yes,
yes, correct. So therefore, let him file an affidavit here. Or if he says, no, you go and file appear before the.
Your Lordship,
I don't want my property to be sold at a really throwaway price. What they other at the first auction, my lord, 3 bidders came, and the same amount of money I am ready
We'll do
to
one
pay.
thing.
Your Lordship,
I'm
proceeding
ready to pay.
Mr. Sharma.
attachment was done in 6 months before. It
Mr.
is in the
Sharma,
well
Mr.
known.
Sharma, we by balancing the equities, what we'll do, we'll issue a short notice. We'll say they don't, not to you, we'll say to the private respondent, don't create any other third party right. And you file whatever you want to file.
And Your Lordship, my right to raise the preliminary objection.
That will be kept open.
Yes.
They should not registered sale because registered sale will burden me more. I'll have to pay another 5-6 lakhs.
That we cannot perhaps because the sale was confirmed on 9/8/2019.
9/8, my lord. 9/8, only
Yes.
August.
August. We are in the end of November.
No, at the end of it is only in the month of August they have said. August is my lord, August, September, October, November, only 3 months.
So now how
So
can
what
we go
I
back?
submit, my lord, what I submit, my lord, subject to what your lordship may say, your lordship will protect me, my lord, that as on today, my lord, maintain status quo. I'll pay some amount. Whatever amount your lordship says,
No,
I'll pay.
your payment that will come later when we are prima facie satisfied that there is violation or application of the rules 8.5 and 8.6 which you have said.
Yes.
Mr. Sharma says that 8.5, 8.6 has no application at all. It arises from an OA, not from a proceeding under the SURFACI.
Yes, Your Lord. And
if it is an OA, we go by
It has
petitional
been
matter.
done by recovery officer, everything. has been done
Certificate
by the recovery.
issued, you put for execution, sale is there, but there is no question of any SURFACI operation of the SURFACI Act.
Yes, Your Lord.
No, let them file an affidavit to that extent.
Or
Or if he
it is
says,
a spell sine qua non.
alternatively, if my learned friend is saying that there is a provision for filing appeal, I'll go and file an appeal because I did not go and file appeal because of that
Has also
provision
been
of section
Your
30.
Lordship. 1 month time
30
is
and I'll deposit that 50% of the amount. That also I can do.
But that appeal,
But yes,
there is a period prescribed for that.
30 days, Your Lord.
That repetition also you have.
The limitation I can explain, my lord. I think. And yes,
No, that is up to the tribunal.
but for the timing, your lordship will maintain that the
Period of spell sine qua
thing will
non
not
for
be
the
done.
petitioner.
My lord, if the
The petitioner
sale is registered, my lord, it will prejudice my right.
has put to challenge an auction process undertaken by the under the aegis of the DRT pursuit property of the petition situated at Karnataka. It is contended that there has been violation of of the security interest enforcement rules, 2002, framed under the Surface Act of 2002. More specifically, Rule 8.5, 8.5, and 8.6 is submitted that prior to the auction date, no valuation report was of the property was obtained, and the 30 days time which is said to be mandatory has also not been given to the petition, who is the borrower. By drafting notice for a judgment of the Honorable Supreme Court, the case of one, it reported into the learned senior counsel has submitted that the aforesaid provision of law has been held implemented, and infraction thereof would make the entire proceeding void ab initio. It is further contended that in the aforesaid case, the Honorable Supreme Court had dismissed the assets preferred by the purchaser against the decision of Honorable Division Bench of the Karnataka High Court, in which the right of the borrower was recognized. Per contrast, Sri M. Sharma, learned counsel appearing for the respondent bank, has raised a preliminary objection on the maintenance of the writ petition itself. He submits that apart from the fact that there is an appellate provision, the very basis on which the very premises on which the writ petition has been structured is erroneous. He submits that the proceeding is under the Recovery of Debt and Bankruptcy Act 1990 and not under the Surface Act of 2000, and therefore the question of applying any provision of the rules framed under the Surface Act of 2002 will not arise. On fact, he submits that on each date, the petitioner, who is the borrower, was represented and a valuation was also done, and the sale was also confirmed on 9/8/2019. And in this connection, he has placed on record a copy of the order of confirmation of sale issued by recovery officer, DRT Mohan. Para. That notice be issued written on on 11th of December. Sri Sharma, the learned counsel, accept notice on behalf of Reserve number 1 and 2.
Yes, sir.
That step be taken. Let extra copy of the writ be served upon him by tomorrow. That step be taken for service of notice upon the respondent numbers 3, 4, and 5 by registered post date by tomorrow. 3. Thus, the learned senior counsel prays for an interim order. On the other hand, the maintainability of the repetition itself is an issue raised by the respondent bank. This Senior Counsel submits that to the information received, though the sale has been confirmed, the same is yet to be registered.
And we are willing to pay the amount.
And the petitioner is willing to
deposit
pay
the entire amount.
the entire amount, including the cost oblique expense incurred
by the
purchaser in the transactions held in the meantime. Considering the above, it is and balance the equity provided. And this court is of the opinion that while no blanket interim order can be passed in the case of present nature, provided that the respondent number 3 and 4 shall not create any third party interest on the property concerned till the next returnable date. It is further observed that any action taken for registration of the sale would be subject to further orders that may be passed. Sarah, the maintainability of the however is kept open.
My lord, your lordship had lucidly, my lord, incorporated all the submissions, only one submission, my lord. Page 37, my lord. Page 37. 37, my lord. No application has been filed under Rule 60, 61 or 62. No opportunities was given to us for filing this application under this income tax rule. Because that is the last
right,
chance.
Your lordship.
That
It
is
is
the
right.
last chance.
It is the right available to the
Page 30?
Page 37. No application has been filed. No notice was given. That is the last chance for me to make the payment.
So far as the 37.
37.
So far as the observation made in the order dated 9/11/2023 that no application was filed under Rule 60, 61 or 60 of the second schedule of the Income Tax Act 1961, it is the submission of the learned senior counsel for the petition that since no notices were issued, such application the question of
no opportunity was.
The question of submitting such application cannot arise.
Your lordship, it is right available to.
Let's just give notice.
It is right, statutory right given to them. It is not.
We are retaining this confirmation order.
Yes, sir. Yes, sir.
And you file affidavit.
I have the
Yes,
next
sir.
also.
Your lordship.
Why have you relied on Sadasiv?
Yes, your lordship, is not
Alternative.
is not maintainable, your lordship. Repetition is
पता
not-
लिखित पर है। Sri Sharma, the learned counsel for the bank, in support of his submission, questioning the maintainability of the certification, has relied upon the case of Sadasiv Prasad Singh versus reported.
May I please, your lordship? Matters pertain to National 5A Act, my lordship.
Yes.
The brief effect of the case is that on 14/12/2012, a notification was published by the Union of India under Section 3A(1) of the NH Act 1956 for building maintenance, management and operation of NH 29 in the district of Karbi Anglong, Assam. My lordship, the notification is at page 17, my lord.
Yes. What is your reward?
My lordship, subsequently, the notification under 3D of the Act was also published in the Gazette of India on 30/03/2022 and The petitioner name is also reflected in serial number 352.
Yes.
That is in page number, my lordship. 24, 21. My lordship, page number 24. Serial number 350.
You want an opportunity to be given to you before
Yes, yes,
determining the compensation amount.
Yes, my
That is
lordship.
what you are seeking.
Yes, my lord.
Yeah.
That my lordship, dispose of it that way, my lord. The problem is that, my lord, that earlier lordship passed an order, my lord, to hear both the sides, my lord, and to decide the issues. And we could not decide the issues in the absence of the other parties, my lord. So, my lord, both the sides is required to be heard and pass
Other
an
party
order.
means the petitioner.
My lord, petitioner, his name was, my lord, published in the 3D, but the another person filed a repetition and stating that he purchased the land. So, lordship passed the earlier order that we should.
That tea garden.
Not,
It's
it
not
is not
tea
a tea
garden,
garden, it is individual land.
Individual land.
And there was another matter where some tea garden had
But
purchased.
that is another part. It is not in respect of this land, my lord. It is under dispute, my lord.
Okay.
There is a mutation.
Only prayer
Both the
is that
sides.
there is
If
a
you, Mr. Chutia, if you are agreeable, we can dispose this.
Yes,
also.
sir. Yes, sir.
Heard. Your name?
Epukon.
Heard. For the petition. Also heard the standing council. On Union of India, who is appeared? What is your name, madam? D. Bormon. D. Also heard MS D. Bormon. Senate Council appearing on instruction of the R.K. Talukar. Senate thesis.
No, 2 and 6, my lord.
No, who's for Union of India?
Union of India.
Anyone? CCC. As Barua, is she there?
Union of India.
As Barua is there? No. Your colleague, Miss As Barua. Anyone who's the CCC? RKD Chaudhary? Okay. Also heard the RKD Chaudhary Ranit, Deputy SGI, for the response number 1, comma, MST Bormon, Senate Council appearing on instruction of the RK Talukar, Standing Council NHIDCL for response numbers 2 and 6, and 3 HTS.
3, 4, and 5.
Senate Standing Council KEC for response numbers 3, 4, and 5. Considering the reverse and subject matter involved, comma, this petition is taken up for disposal at the motion is that the petitioner claims to be the owner of a plot of land which is the subject matter of an acquisition process initiated under the National Highway Act of 1950. Full stop. The notification published on 30/3/2020 in the Gazette of India contains the name of the petitioner against serial number 352.
352, my lord.
352. Full stop. However, comma, another person had earlier filed a writ petition in court, which was registered as WP 4543 of 22, claiming compensation on the state plot of land. The aforesaid petition was disposed of by an order dated 19/12/2022 by giving liberty to the petitioner therein to approach the competent authority under section 3H within bracket 3 and 3H within bracket 4 of the National Highways Act of 1956, and thereafter and also
make disbursement.
and also directed the competent authority to provide opportunity of hearing the affected party. It, however, appears that due to the absence of all the affected parties, the disbursement could not be made. because the learned counsel for the petition has submitted that the present approach of the petitioner is on a very limited ground. He submits that in the process of determination of the competence command, the mandate of law as provided in section
3H3.
H4 H4 may be followed only.
My lord, 3H3.
Follow para. The effort is sufficient. He is not opposed in principle by the learned counsel for one as a footnote. This court has noticed that the procedure laid down in the aforesaid provision of law are mandatory in nature, and therefore, the interest of justice would call for passing an order direct competent authority to follow the aforesaid provision of law while determining the compensation to be paid to the affected party. In view of the above, the institution is disposed of by direct competent authority to follow the mandate of section 4.
PS3 is the apportionment, that PS4 is the reference to the district judgment.
PS3 will
PS3.
PS3 while determining the the amount of compensation as well as the apportionment thereof amongst the
and determination the person who is entitled to get the compensation.
According to
What's the right?
Maybe the lordship. My thought, this is a case, my lord, of demanding 2% forest royalty for grant of building permission, my lord. In earlier occasion, my lord, your lordship has passed an order. The similar issue, my lord, your lordship will find.
you are a private person.
Yes, my lord.
You are not required to pay the forest royalty.
No, my lord.
Madam?
There are many similar cases pending already. Interim has also been given in the other case.
Your lordship's order is at, my lord, case 38, my lord, chapter 6.
38.
The main case number is 2040 of 2023.
Yes.
Maybe that.
At case 38.
Heard PSP the learned counsel for the petition. The grievance of the petitioner is with regard to the insistence of payment of 2% forest royalty for issue of NOC, public building permission. It is the contention of the petition that such demand would not be applicable in case of a private person who who undertakes a construction for his own purpose and not for any commercial purpose. Attention of this court has also been drawn to certain orders passed by this court, including an order dated 12/4/2023 passed in the brief 2040 of 2020, whereby notices were issued and interim order was also passed. So that notice issued, returnable by 4 weeks. M. Polita, Chief Secretary, yes, as Burwa, State Council accepts notice on behalf of one. Only. There are others also. Urban housing, no. A Polita, M. Polita, for respond number
2, 3, and 4.
2, 3, and 4. Madam Kutia? as Shrutia for 5, 8 and 9, and 6 and 7, mines and mineral department, Mr. Burua.
Yes.
Mines and Burua hole
1,
1, 6 and 7. Parent extra copies of the repetition have to consider and counsel for the response by tomorrow. Also, Sarah. 3. Thus, learn counsel for the praise for an interim order. After consideration of the facts and circumstances, it is observed that the fact of non-payment of the forest roll would not come into the way for consideration of grant of building permission in accordance. Sarah, please along with W.
Obliged.
Meet people.
Yes, Mr. Kaustik, what is this?
Malad, it's a very limited prayer, Malad. Malad, the petitioner purchased a plot of land pursuant to after obtaining NOC and all. And that DAG comprises only the land which the petitioner has purchased. Now, Malad, this land surrounded by 2 other DAG number, Malad. There are disputed between the owners of those occupiers of that DAG number, and there is no identifiable boundary marks. And therefore, Malad, your lordship will find one application has been filed before the circle officer at page 30. One paragraph from that application, Malad, what I have prayed for, Malad.
Page 30.
Page 30.
Yeah.
Page 31, paragraph 8, Malad. This is my grievance, Malad. Tag number 693 is surrounded by the, Malad, finds page 31.
Yes, what is your tag number?
My tag number is 693. Originally, this DAG had 3 katha, 12 lesas land, out of which 1 katha 2 lesa was acquired for the purpose of construction of the highway. The remaining land was 2 katha 10 lesa, and the pattadars has sold these 2 katha 10 lesas by way of a registered sale deed
to you,
to me. And after my mutation, all the pattadars' names have been deleted. I have annexed the copy of the Java. Now, this DAG, my lord, is surrounded by DAG number 691 in the northern side and 675 in the western side.
Six 91 on the northern side and 6.
Northern and eastern side 691.
Western you said.
My lord, and 675 in the western side.
Okay.
So there are some dispute among the occupiers of these 2 DAG, and now there is no demarkable, identifiable boundary marks in the surrounded DAG. To avoid future, my lord, dispute, my lord, I prayed for deputing a Latmandal to measure the DAG number 691, 693, that is my DAG number, my lord, and identify my boundary. And the circle officer is empowered to do so, my lord, under the Assam Land Regulation.
But you're right, request your advance whatever is request under the 2012 Act. They've been passing.
They notify surveys in a standard form. Let him approve, so within the 30 days the statutory period that will be disposed of.
They've been passing numerous orders, demarcation.
Notify survey. Yeah.
Repeat for Senate Council. Mr. Bora, which is full this of Senate Council for the petition also heard Ms. N. Portler, Senate Council Representative, as well as Bora,
20.
Senate State Council. Subject matter another party. The petitioner claims to have purchased a plot of land measuring 210 less than covered by tag number 3969
693.
new, 498 full of construction number 185 new, 7 full of Odilapur SBI LA tour Odilapur village under the Jalukuri by a registered sale date 22/3/2020. Is submit the subsequent the the name of the petition has also been muted and his name has entered the right record of right.
Record.
The grounds of the petition is lack of proper demarcation over the plot of land and as a result of which the petitioner is facing harassment, more so because of some boundary dispute with the incumbent and between the incumbent holding possessing land over dock number 691 on the northern side of the land of the petitioner and dock number 675 on the western side of the land of the petitioner. It is accordingly submitted that a direction for deputing allotment and demarcate the land of the petitioner. On the other hand, both MS Borda and Borua and counsel for the respondents have submitted that the issue involved is covered by the Assam Right to Public Services Act 2012 and demarcation is one of the notified services. It is also submitted that necessary office memorandum has also been issued under the Act laying down that the Assam Right to Public Service Act 2012 indeed provides for delivery of notified public service to the people of the state, and demarcation is one of public services is notified. The corresponding office memorandum was issued on 21/12/2020, whereby the procedure has also been laid down for issuance of demarcation. This court has also informed that a number of cases of present nature has been disposed of by direct the incumbent to approve the jurisdictional designated public servant by servant for doing the need for demarcation. In view of the above, the present by direct to submit the prescribed standard application to the jurisdictional designated public service by depositing the requisite user charge within a period of 15 days, which may be done within a period of 15 days on receipt of the state authority would dispose of the within the time stipulated in the act in the statute holding the according to the
Obliged, sir. Valuable.
Please, my lord.
My lord, the petitioner is aggrieved by the rejection order, my lord, against the complaint filed before the banking ombudsman. My lord, the petitioner is a retired ex-serviceman, my lord. After the retirement, my lord, he had applied for fixed deposit receipts, and accordingly, my lord, at Annexure 1, 5 numbers of FDRs were issued by the concerned bank. And my lord, the maturity dates of the said
But let us
FDs.
see the ombudsman order.
My lord, the impugned order is at page 44. 44, my lord. 44, my lord. My lord, the relevant portion is at page 45, paragraph 2, wherein the complaint has been addressed. May I read?
Yeah.
Please refer to the caption complaint.
They said that you have, it was closed and it was intimated to you.
Yes.
And you deny those.
Yes, the bank is saying, my lord, that the FDs were prematurely, my lord, opened by us and the money was credited to internet banking. But my lord, in cases of fixed deposit receipts, my lord, unless the customer gives the written instruction, the FDs cannot be closed. It is only in cases of term deposits that it can be
For
closed.
physically, the FDs are in physical form.
We have to give a written instruction. My lord, I'm
Now, is the money safe or now? Is
My
the
lord,
money secure?
is not safe, my lord. It has been transferred to different accounts fraudulently, my lord.
Not to your account.
Not to my account, and then it was debited out, my lord. The
Ultimately, you have lost the money also.
Yes.
Your grievance is not only with the procedure of adopted, but you have also lost the money.
Yes. I have lost the money. My
How
lord,
much was the amount?
my lord, the 5 FDRs were each of 1 lakh rupees, my lord. So, my lord, if we take the maturity value more than 5 lakhs.
Principal was 5 lakhs.
Principal was 5 lakhs.
And where is the procedure which you are
My lord,
banking upon? That if it is in the physical format, you have to give a physical application.
My lord, I have placed the.
Yes, you have given some.
My lord, this is the. No, my lord, below that, my lord, 2 pages, my lord. This is the FAQ, my lord, which I have downloaded from the SBI personal banking. My lord will take, my lord, the clause 11. Roman 11, my lord. That says, my lord.
These are FAQs.
Yes. This is the instructions. State Bank. My lord will see, my lord.
Okay, we have seen. Third page of the learned counsel for the petition. The petitioner is a retired Havildar
Yes, my lord.
of the
Indian Army, my lord.
Indian Army.
Indian Army.
And after his retirement command, he had opened 5 numbers of FDs through STDR in the State Bank of India. Which branch?
Golaghat branch.
Golaghat branch. The aforesaid FDRs were, however, closed prematurely, and the amounts were also fraudulently transferred to some other account. The petitioner had raised the grievance for the ombudsman, which, however, by the impugned order dated 21st of July.
My lord, that would 13/7, my lord. 13/7/22.
Where
At
do you
the
get?
bottom, my lord. At the bottom. That is
13/7/2022.
Yes, my lord.
It is too late. 13/7/2022.
Yes.
Has rejected the claim put up. The learned counsel has submitted that apart from the fact that the reasons assigned are erroneous, such reasons are also not legally tenable, as the STDR in question were made physically, and such STDR can be closed only in the branch and only a full stop. he further submits that as per information received from the bank, on the subject of FAQ on ETDR of the ESTDR, it is clarified that only when such term deposit is made on E-mode, the same can be closed through E-mode, and whenever such deposit is made physically, the same can be closed only in the concerned branch. That how do you explain the delay?
My lord,
Why the delay?
my lord,
More than a year, what are you doing?
my lord, he has been pursuing to the other authorities also, my lord.
What authority? You are going to ombudsman passes an order to 2022.
No, my lord, actually, my lord, after his retirement, my lord, he has joined other job as a, so my lord,
5 lakhs is not important for you.
my, it is important, my lord. But
If you don't need to file. Somebody is enjoying, let him enjoy.
But he is not that much literate also, my lord. That is.
He is not?
He is not that much literate, my lord, to.
He is retired. He is retired from the Indian
He
Army.
is a Havildar, my lord.
Where is the question of literacy here?
My lord. Well, he has been pursuing, my lord.
Somebody is enjoying 5 lakhs, let him very botaning.
It is his hard-earned money, my lord. That is why.
For somebody, it's a windfall. It's already spent also within 1 year. 5 lakhs, 1 year it will not last.
No, under the rule, my lord, there is a.
Where is your explanation?
My lord.
Of 1 year.
My lord, there was a, in between, my lord, there was COVID also, but.
COVID after 22.
Yes. But problem is that, my lord, he is.
Did you notice? By 4 weeks. Yes, the borrower for 1, 9, 3 years for another state council exception of the government. 1, 2, 8, 9, and 10. That is the copy, not that for step for service of this phone numbers 3, 4, 5, 6, 7. Be taken by a step possibility.
Obliged.
This you can take back. This were effective you are returning.
Notice them served on the bank, my lord, and ABTG has been filed.
May I please, Lordship? Lordship, I'm appearing for respondent number 1 and 2. We have received instructions to appear today only. We'll file our wakalatnama tomorrow.
It doesn't matter who is 1 and 2.
Bank.
Bank.
State bank. Okay. Have you got the instructions or not?
Only the instructions that we have got is that the property involved in the application has been already sold out in auction as per the recovery proceeding.
Property sold out.
Sold out, but position not given one yet. There is an order of 23 of October 2023. But where I am there, my lord, is a very short question. If you want to get some instruction, file something, let them file by tomorrow.
Yes,
after tomorrow.
You filed your format wakalatnama also.
Yes,
Can
yes.
you give me that? Please let us issue notice.
Here, my lord, the meat of the matter is that there was one-time settlement. But and I also deposited the amount of 6,000. I was asked to deposit.
How much?
60,000 in 12 lakhs. Final settlement. Then, my lord, I was asked to deposit the interest part. I deposited the interest part of 60,000.
Then my PRP account. for the petition, who is aggrieved by any auction sale pertaining to the property which was the subject matter of a loan agreement to submit that due to circumstances beyond control of the petition, the loan could not be paid in time. However, it is mentioned that there was also a settlement between the bank and the petitioner, and it was only due to the passing away of the guarantor. Guarantor passed away.
Yes, my lord. Father had taken the loan.
Passing away of the Badrul Haq is your father.
Yes.
Of the father of the petitioner, who was also the guarantor in the year 2020, that the balance amount of settlement could not be paid. Full compare. This court on 17/11/2020 had directed the petitioner to serve the bank person to which, madam, your name?
As they, on behalf of KK.
MSSD counsel is present in the court who submits that formal wakalatnama will be filed. He also prays for some time, as they also submit that the auction sale has already taken, and therefore no relief can be granted to the person. That notice be issued, returnable on 13th of December. MSD council accept notice on behalf of person number 1 and 2. Put supply extra copies of the written have the confirmed by Sarah. That's have to take for the responsibility by registered. Considering that matter as arisen out of a proceeding under CRT Act, this court CRT Act, wherein the role of a writ court is absolutely responsible. This court, while declines to pass any interim order, observe that the purchaser cannot create any further third-party rights on the property till the next return.
Habla.
That is lordship. My lord, in this case, my lord, I have appeared for the respondent 5 and 6. Yes, my lord.
Lordship has not yet issued notice, and no caveat is there, my lord. So, under the circumstances, your
I
lordship
have right to, my lord, appear, defend my case, even if my lord, the caveat is not filed.
If we dismiss in limine, will you write a proof?
Subject to my lord approval, you will.
Then also will record your name.
My lord, some relevant facts, my lord, this motion says
Let me submit my case, then
Yes.
you can always.
I'll, if necessary, my lord.
You filed wakalatnama or not? Have you filed your
Yes,
wakalatnama? You filed wakalatnama?
It is reflected on.
Okay. Yes, yes.
My lord, what happened, petitioner, before your lordship, are the shareholder of the cooperative society.
How many of you are there?
3, my lord. Shareholder, and there are 2 of them were, my lord, elected board of directors, my lord.
3 petitioners.
3 petitioners.
3 petitioners.
We challenge the, my lord.
2 board of directors. 2 directors.
Yes, my
Out
lord.
of the 3, 2 are directors.
Directors, and 1 is the, my lord, shareholder.
Oh. Okay.
We challenge the, my lord, election of respondent number 6 and 7 as board of directors. Election held on, my lord, 27, result declared on 29, my lord.
You are earlier challenge, or dispute, you are challenging.
Yes, my lord.
This is the subject matter.
Yeah, this is the subject matter. We challenge the election of respondent number 6 and 7 as a board of directors. Election as a board of directors.
Mr. Ahmed, you are for 6 and 7.
My lord, respondent number 6 and 5 and 6 and 7, lord.
Your turn.
My case is that, my lord, under the provision of section 42 of the Assam Cooperative Societies Act 2007, for contesting in election, a board member has to be present in 2 AGM in previous 5 years.
Yes.
Accordingly, during the process of election, we objected to that before the my lord returning officer, and thereafter, returning officer has not considered the issue. Then the record was taken away by the returning officer. After on 5th, we filed, my lord, a representation before the respondent number 2. I registered with the election authority under the rule, my lord.
You filed
Representation in terms of provision of the rule, my lord. Rule 27. It is required to submit it within laws. Rule says it should be submitted, may be submitted within 3 days, my lord. We submitted after 3 days, that is 7 days, 8 days. Thereafter, registered after considering the submission, they also submitted against some of the members. Respondent registered after hearing the parties, including the my lord respondent, passed an order annexed to page 20.
Page 20.
20, my lord.
Yes.
My lord, order, first paragraph, 2 complaint petitions were submitted by Hassan Ali and others. My lord, petitioner herein.
You are Hassan Ali?
Yes, my Hassan Ali, one of the petitioner, and others is there, my lord, they are petitioner, on 5/9/23 and 13/9/2023 regarding the illegalities in the AGM election of the Tengaguri Somabaya Samiti Limited. Again, 2 other complaint petitions were submitted by Jaidur Rahman, my lord, and others, and Guljar Hussain and others. Guljar Hussain and others, my lord, the respondents, my lord, on also respectively regarding the LMS. Then, my lord, 3rd paragraph, my lord, notices were issued. They appear before the my lord register. Then, page 21, 2nd paragraph. The petitioner stated that during the process of AGM election of so and so held on 27/8/2023, the nomination
Mr.
of
Ahmed, what is your name? What are your names?
My lord, name is
Jahanara Begum and my lord Abdul Barek.
You are not Guljar.
No, my lord. Guljar, my lord, he has filed a writ petition challenging the order of register. Same order. In that case, my lord, it was stated. I have annexed the copy of the order.
What is it? You are Abdul Barek and Jahanara.
The Jahanara.
Just a minute.
With regards to my lord,
Just a minute.
lord.
Yes, what happened there?
Then, my lord, with regards to Guljar Hussain, his election was interfered by the registered, and he has challenged the writ petition. The honorable court was pleased to stay the entire order, my lord. Entire order. We are not for stay. We are for, my lord, stay of the, my lord. We are before this honorable for not considering the representation of the petitioner to the effect that the respondent number 6 and 7 are not qualified, my lord. In the present order, I am reading, my lord. In this order, in the last paragraph, register has rejected our prayer.
Chaudhary, your this case which has been passed in Guljar's case,
yes,
will probably not help you.
No.
You were saying that the complaint which you had lost,
yes,
for the registrar,
yes,
has not been properly dealt with.
Yes,
the issues, the grounds of challenge,
yes,
questioning their eligibility,
yes,
to contest the election,
yes,
that they were absent in 2 of the
yes,
AGMs in the last 5 years.
That's previous
that,
5 years.
So that aspect has not been properly dealt. You want
considered in a different way. My lord, what happened? Election was held in the year 2023. Previous 5 years, Lordship kindly see section 42. Lordship kindly see. Section 40, subsection 2.
Yes.
Section 40, eligibility for a director in cooperative society. 2,
such member has patronized the services of the cooperative society during the previous financial year to the extent and in the manner specified in the bylaws and
Lordship, otherwise the registrar has passed an order, and if your Lordship kindly come to page 23 of the writ petition, your Lordship, that is the order of the registrar, your Lordship.
What is the term? 5 years?
5 years.
5 years.
5 years. And now here it has been reflected, your Lordship, considering the above fact. Page 23, the second paragraph. It is pertinent here to say that since the AGM of the so-and-so society was not held since 2019-20, the qualification under Order 42 of the Act for not attending at least 2 AGM in the previous 5 years cannot be traced into service. Hence, the complaint of the petitioners against Jahanara Begum, Gulzar Hussain, A. Barak, so-and-so, regarding the applicability of the above mentioned provisions of the Assam Cooperative Societies Act does not hold water.
that is the, my lord, finding.
That is the finding.
Law says previous 5 years.
Okay.
My lord, my lord, point has been answered by this honorable court, my lord, the petitioner, my lord. My lord, filed a writ petition before this honorable court for permission, lordship, to contest the election, same election, lordship. And that was, my lord, the honorable court has, my lord, directed to accept their nomination, lordship. Now he is, my lord, the petitioner is taking, my lord, advantage. My lord, he was also, my lord, having no, my lord, attendance, lordship. He is taking advantage, lordship, but I cannot take. My lord, that is his plea, lordship. That point,
He
my
is
lord.
similarly placed with you.
Yes, lordship, I kindly see. This is one aspect, lordship. My lord, the period is, my lord, 2016 to 15 to 2020, my lord, 2022. Out of, my lord, that, my lord, 2019-22 till, my lord, 2023, no election AGM was held, lordship. So if the AGM is not held, lordship, question of, my lord, appearance attendance is not, does not arise, lordship. My lord, the period, lordship, earlier period before 2019, that should be taken into consideration. That is, my lord, observation made, given by the, my lord, registrar.
But law says previous 5 years.
Now, let me submit, you can get opportunity. Now, lordship, on this same ground, lordship, the honorable court, my lord, that is WPC number 4588, 2023, is Soban, my lord, and 4 others, lordship, permitted to, my lord, submit nomination, and that was directed to my lord.
And they are not Supan, they are
not, we are not challenging their election, my lord.
Raidur, Sahidul, and Hassan.
We are not challenging this.
Ahmed.
In that case,
They have
my lord,
also take permission, my lord. That order is, my lord, not with me, lordship, now.
no, my
That
lord.
cannot be denied, lordship.
No,
I'll submit that
no, my
by
lord.
affidavit, lordship. On
No.
the other point, lordship, the question of, my lord, maintainability of that petition, lordship, that is submitted, was submitted before the registrar, lordship, has been answered, my lord, by this honorable court in WPC number 6450, 2003.
I have annexed the document.
Yes.
I have annexed the certificate.
Yes, that is annexed. That cannot be.
That is
Well, that can
that is
be
a part of the record.
Okay, we'll issue notice at
My
this
lord,
stage.
yes, that can be without any question.
Under similar circumstances, this honorable court has stayed the order. I have the copy.
Statement.
My lord, not to participate in the election, my lord. The election, my lord.
Elected
Already
members.
result is declared, lordship.
Elected members.
Already the result is declared.
My lord, after the election, my lord, section 4.
My lord, that application within 3, if any dispute arises, my lord, within 3 days, kindly see section 20, rule 27.
That is not mandatory, my lord. That is a directory
Yes,
provision rule.
mandatory. On the
Same society in earlier occasion, my lord. Elected,
that
then my
period,
lord,
that period has gone.
under similar circumstances.
And that writ petition is now in fact was lordship.
That is pending also.
Whatever may be, if cause of action does not survive, that is not applicable in this case. Now, my lord,
Kindly see section, Rule 27, Lordship. Of the
That may be read
Assam-
along with, my lord, section 128 of the Act.
My lord, the
Limitation
rule-
Act will apply, man.
Okay, we'll issue notice. Heard to JMA Chaudhary Learned Council for the petition. The petitioners have to challenge an order dated 3/11 passed by the Registrar of Cooperative Societies by which the complaint of the petition against the election of the as one of 6 and 7 questioning their candidature as directors of Tengagudi Samabaya Summit Limited Modi as rejected.
Yeah.
By referring to section 42 of Assam Cooperative Act 2007, there is a requirement for a director to be present in at least 2 numbers of AGM
in previous
file. And that condition was not fulfilled by private respondent number 7, and therefore their candidature itself was to be interfered with, and this aspect of the matter has not been properly dealt with by the registrar in impugned order dated 3/11/2020. Para. To notice. Para. 3. Amit Learned Council has entered appearance. Now, who has entered appearance on behalf of the respondent number 6 and 7 has, however, raised the issue of maintainability of the report. They submitted that the present petitioner had himself earlier approached the court to allow him to file the nomination on the ground that the embargo provided under section 42 should not be made applicable in view of the extraordinary circumstances going COVID pandemic, and he himself had contested the election. It is further submitted that the appeal which has been rejected by the registrar was otherwise not maintainable, as the same was not filed with period of limitation.
Rule 27.
3. The bottler. 3. He bottler and standing on the cooperation while opposing the writ has submitted that the issued order dated 3/11/2020 contains reasons based on statutory provision, and therefore the present may not be effective to go to the adequacy of the reason, as such reasons prime facie based on statute holding people. That notice is returnable on
Short date so that, my lord, meeting should not be held.
15th of
That
December,
I object, Lord.
the board of internet standing cost corporation but except on behalf of 1,
1 to 4,
2,
Your Lordship.
3, and 4. 5 would take the second the internet cost except on behalf of 6 and 7. That extra copies to the internet count. Therefore, the internet count by default. That step be taken
By
for
Dusty will,
service of upon this number 5 registered to it
by the, by the,
step by the mode 3. Chaudhary internet count for the space for a debut serve state response by just good run and such justice service be routed through the registry of entity notice accompanying justice service, the next date, that is 11 12 2020, 15 12 2020 is to be clearly reflected. 3. Chaudhary pays for an interim order and in this regard has also placed an order dated 2/12/2019 passed in WP 8891 of 2019. This court, however, is of the opinion that since the impugned order dated 3/11/2020 of the registrar contains reasons, contains reasons which prior facie does not appear extraneous, passing of any blanket interim order is declined. It is, however, observed that all further actions taken by new board of directors would be subject to the outcome.
My lord, the standing council may produce the record too, for example, because relevant record is necessary in this case.
Bring the record.
Oblige.
May it please the Lord.
Yes.
If the matter pertains to non-payment of compensation for acquisition under the National Highways Act, my lord, the petitioners 1 and 2, they are senior citizens, my lords, and they are residents of Dergaon. Now, my lords, in Dergaon town, my lords, the father of the petitioners had built a cinema hall, my lord, which is covered by 1 bigha 2 katha 5 lachas of land, my lord. It's in the main town area of.
Pleadings have been exchanged.
Pleadings have been exchanged, my lord. The issue is in a very narrow campus, my lords, whether we are entitled for compensation or not. My lords,
they have denied the compensation.
They have denied the compensation. What had happened, my lords? My lords, on 20/03/2020, the substance of acquisition was notified in the newspaper. However, our land was not included in the substance of acquisition. So therefore, my lords, we were of the opinion that our building, which is the cinema hall, will not be acquired. However, when the assessment and the survey took place, my lord, what had happened, my lords, the right of way came till the first pillar, half of the first pillar of the cinema hall, my lord. My lord, for as an illustration, if my lords kindly peruses a photograph, that would be very clear, my lords. Page 26.
These matters which are factual in nature, how is that?
No, it's admitted. The factual nature, it has been admitted, man. It has been admitted
you
by.
have been affected
Yes,
by
yes. Well, I'll come to that, man. Lordship, for a moment, page 26.
Mr. Mohammed, if you can proceed, if these are admitted, then
These are admitted. These are admitted.
Question of how much compensation will be there, that part we can perhaps deal with. But if factually they are disputing, that you are not even affected by the.
They are not disputing, my lord. My case is on a different footing.
Not admitted, my lord.
Well, I'll submit, my lord. I'll try and satisfy you.
Already affidavit is very
Not
clear as
admitted.
regards the standard.
And Mr. Borua for
I don't have role. It's been not by something as party.
two persons are saying not admitted.
My lord.
You need to have a bigger force.
Adversarial litigation, they will always say no, my lord. I'll satisfy your lordship. My lordship would kindly hear me for 5 minutes.
No, factually, if they are
No,
disputing.
it's not about, my lord. Factually, my lord, it has been admitted, my lord. What I am on, my lord would kindly produce the photograph for a moment, just to give a perspective, my lord. Page 26.
Mr. Mahanta,
My
you
lord.
may be correct. Their denial may be their denial may not be having any basis. But can we really go into that?
Because my, there's a survey, reports are there, my lord, which they have not denied in their affidavit. I'll come to their affidavit, my lord. I'll first place my case, my lord, very briefly, my lord.
We'll take for disposal if you want. Not
Yes.
today. Today we have got the other matter.
My lord, my lord.
Yes, what do you say?
Lordship is a government landlordship.
I agree to that, my lord. I agree to that. I'm not on that, my lord. What I'll,
And
in a
lordship, in
nutshell,
this
I'll
regard-
explain, my lord, what is my point.
Now, was it affected?
Lordship.
Was there any of the land affected? Where the cinema hall is there?
Lordship, 7 pillars of the that building is under the highway land.
Yes.
Government land.
Government land, my lord. My lord, lordship would kindly produce one
You had
document.
encroached government land.
My lord, I'll explain what had happened, my lord. The structure is
And for how many years did you utilize the land?
pre-independent structure, my lord. And government land, my lord, just half a feet of land, my lord. I'll explain what had happened, my lord. Now, the pillars, my lord, the pillars where the cinema hall starts, my lord. The starting pillars, the half of the pillar is government land and the other half of the pillar is my patta land. Now, I'm not claiming any compensation for the government land. Of course, I'm not entitled. But lordship may kindly peruse one document which they have not denied. 36. Page 36. Now, the structure has been surveyed by the respondents and they give a finding, yes, just next to the ROW, my building starts. Lordship would see this is by the general manager NHIDCL, the first paragraph. Inviting a reference on the above mentioned subject, it is to inform that the structures lying at the edge of the proposed right of way for the subject cited project, the valuation of structures may be measured from proposed right of way till the next nearest load bearing wall column subject to the safety of the building and structure. Now, this is, Lordship would note, this is by the general manager P, NHIDCL, PMU Jorhat. Now, Lordship would come to their affidavit, my lord, whether they have denied this fact. My lord, look, take up their affidavit for a moment, my lord.
First, let us see your corresponding pleading.
Yes, my lord.
Annexure E.
Yes.
What have you stated? How have you stated?
Yes, my lord would come to paragraph 11 of the writ petition, my lord.
Page 14.
Page 14. The petitioners humbly beg to state that the general manager P so-and-so by letter dated so-and-so addressed to the additional deputy commissioner Golaghat so-and-so clearly stated that the valuation of structure lying at the edge of the proposed right of way may be measured for the purpose of valuation of proposed right of way till next nearest load bearing column subject to the safety of the building structure. However, the personnel carrying out the duty of survey and assessment with clear disregard to the said letter had not measured the building of the petitioners for the purpose of valuation to be paid as the compensation to the petitioners for acquisition of part of the said building. Therefore, considering the fact that the proposed ROW admittedly falls at the edge of the building of the petitioners, sans the portion of the building on the purported government land, which would admittedly stand demolished, the petitioners are liable to be paid compensation on the strength of the letter addressed to the respondent number 6, so-and-so, so-and-so. Now, the fact that my lord lordship had put that query, my lord, whether the structure lies at the edge of the proposed right of way, do I have any document apart from the photos? My lords, would come to the page number 28, my lords, the report furnished by the circle officer, pursuant to my representations, my lord. May I read the vernacular, my lords, or the English translation, my lord? Page 28. 29 is the original. 29. উপৰোক্ত বিষয় সন্দৰ্ভে মহোদয়ক সন্মান সহকাৰে জনালো যে আবেদনকাৰী শ্ৰী মানস বৰবৰা আৰু শ্ৰী সমীৰ বৰবৰা পিতা সোয়েনছো দেৰগাঁও মৌজাৰ দেৰগাঁও নগৰৰ মাজত এটি চিনেমা হল আছে। উক্ত চিনেমা হল 37 ৰাষ্ট্ৰীয় ঘাইপথৰ কাষত অৱস্থিত। দেৰগাঁও নগৰৰ মৌজাৰ সম্প্ৰসাৰণ কৰা ছবি সংযুক্ত পথৰ বাবে অধিগ্ৰহণ কৰা মাটিৰ ওপৰত চিনেমা হলৰ কিছু অংশ অৱস্থিত কিন্তু এই অংশ বিশেষ দেৰগাঁও মৌজাৰ দেৰগাঁও নগৰৰ সোয়েনসো দাগৰ অৱস্থিত এই দাগ চৰকাৰী দাগ মহাদয়ক জনাও যে ৰাষ্ট্ৰীয় ঘাইপথৰ প্ৰতিবেদন দিয়া ROW চীনৰ পিছৰ পৰাই আবেদনকাৰীৰ মাটিৰ ম্যাদী মাটি অৱস্থিত Now, my lords, some portion of the pillars, my lords, is government land, but just adjacent to the ROW, my building lies, my lord. And in terms of the letter, now lordship would come to their pleadings, my lord. What does the general manager say, my lord? My lord, lordship may take up the affidavit in opposition. First, my lords, the page number 51, the name of the person who has sworn the affidavit, my lords. I, Shyam Sundar so-and-so, presently serving as the general manager, project National Highway.
Cinema hall exists or not?
My lords, the building is there now after COVID. As per my instruction, there is no movies, my lord.
No, building is there or not?
Building is there, my lord. Building is there. In fact, there's an interim order to protect my interest, my lord. This honorable court had directed that the valuation of the building should be taken by the authorities so that in case it is demolished and if I succeed in the writ petition, proper compensation has to be paid. Now, my lord, this is the yes, that has been done. NHIDCL, the person who has sworn, my lord, the general manager, lordship would come to where I have stated in paragraph 11.
We have more or less understood your matter. We'll have it some other day.
My lord, my lord.
Pleadings otherwise are complete.
Yes, my lord. Well, their denial won't do, my lord. The survey says, my lord.
But your prayer B, I don't think can be considered. I think A, at best we can.
Well, I'll just check, my lord. Prayer
B for the entire building unless it's
no, not the entire building. The letter says till the next load-bearing column. From the pillars to the next load-bearing column. Whatever it is, my lord, then they would decide.
No, no, C is B, number B at page 20.
My lord, just check. Mandamus directing the respondent authorities to include the. Well, I'll concede to that, my lord.
Entire multi-story.
No, I'll concede to that. Only as per the letter, my lord. The letter says till the next load-bearing column. And that exercise, I'll leave that your lordship would leave it to the authorities, my lord. I'm not on the quantum. I'm only on my entitlement. By virtue of that letter.
Yes, what do you say? Professor, we are not kidding.
Under the
No, other day, but why aren't they entitled to the compensation?
lordship, there are 7 pillars are under the government land.
I agree to that.
So that part of the pillar which is also which is in their land. What left?
The letter is clear, my lord.
Since they are enforcer, my lord, they have constructed the building over the government land, lordship. That is why, lordship, they are not
No, we may not be too much
and
interested.
lordship, their land is published in the 13 gazette notification, lordship. That you cannot challenge that also, lordship, in terms of National Highways Act.
It is not published, my lord. Not
Yes,
published.
my lord. I have annexed, my lord.
Names are there.
Yes, my lord. Government land. Page 60
Government land, I agree.
Page 67, my lord. Gazette notification, my lord.
Government
my
land, I
affidavit.
agree, my lord.
Of my affidavit in opposition.
Current counsel for the parties are in being exchanged among the matter when
The construction of the NH-37, my lord, is being carried out on a wall footing, my lord. That is the. Here only. Yeah.
yes, tell us.
My lord, after 2 weeks, my lord, on a hearing day, if it's possible, my lord, kindly. जरा कोई लोग अपना आपको
Uh,
14th of December, my lord. 14th is a Thursday. 14th of December. Look, can it be on 12th, my lord? 14 is before the vacation, my lord.
not the,
My lord, 14th of December.
yes, the photo. 14th is okay. We do not know what role you will have on the next day.
I'm
Deeply,
appealing on behalf to
Sir, for admission here.
admission. Deeply obliged, my lord. Very grateful. my lord.
But here also, my lord, the petition is agreed by the order passed by the banking ombudsman. My lord, the impugn order, my lord, although was in the nature of the award, and my lord, the certain transactions were, my lord, directed to be refunded. But in the last part of the order, my lord, we'll see at page 63. My lord, here we are agreed by the manner in which my complaint was rejected, my lord, and my right to appeal has been, my lord, closed under the banking ombudsman scheme. My lord, page 61 is the impugn order, my lord. Page 62, my lord, at the bottom, my lord, 9th line from the bottom, my lord. We'll see page 62. It starts with, it was observed that. It was observed that even after the complainant had lodged. Yes. That is what I'm reading, my lord. It was observed that even after the complainant has lodged the complaint on 4/6/21, there were multiple debits and credits taking place in the account of Bharati Kolita. Hence, the deficiency lies in the bank. Well, the ombudsman is observing that there is a deficiency lies in the bank as they failed to mark hold in the account immediately, and rupees 1,34,600 was debited from 4/6/21 to 9/6/21. In view of the above, an advisory was issued to the SBI to pay the disputed amount, which was debited even after the complaint was lodged, and they have complied with the advisory on 18/11/21 and credited 1,34,600 backs to the complainant account on 18/11/21 in good faith. My lord, here what has happened? Well, the fraudulent transaction took place, my lord, from the period 1/6/21 to 9/6/21. But, my lord, the ombudsman passed the award for refund in respect of the transactions from 4/6/21 to 9/6/21 only. Whereas, my lord, the major part of the money which went out from my account was, my lord, on 1/6 and 2/6. So, my lord, although there is an observation by the ombudsman that there is a deficiency in service, but in respect of the other transaction, my lord, there has been no clarity. And what has been alleged by the bank is that, my lord, I have, my lord, sacrificed the INB credentials. However, my lord, at page 46, if your honor will see, page 46 is the version by the SBI after the lodging of the complaint before the ombudsman, and the ombudsman had asked a query from the 46, my lord, annexure 6. My lord, it is mentioned as bank version. My lord, here the RBI has replied, my lord, stating that the complaint pertains to unauthorized UPI transactions of rupees 50,000 and 25,000 done on 1/6. Whereas on 1/6, my lord, there were several transactions, and my claim is that more than 10 lakh rupees were compromised. So even presuming that, my lord, I have compromised these 50,000 and 25,000, my lord, the OTP, the remaining amounts, my lord, I am entitled to get back. And as per the, my lord, the circular of the RBI, which is at page, my lord, 68, my lord. Who is for the respondent? Hazarika, you repeat?
I'm appealing for RBI.
RBI.
Yes.
In case, my lord, I have informed about the fraudulent transaction within 3 working days, my lord, the customer's liability is 0 as per the RBI circular.
No, my lord.
Did you inform? Yes, I have informed, my lord. The fraudulent transaction took place on 1st of June itself, my lord, I have lodged the FIR, and 2nd of June, my lord, with the copy of the FIR, I have visited the concerned branch. And what is surprising here is that the bank has not furnished me reply even after my several representations until 22nd June. That is only before the ombudsman. Representation in page.
Perhaps the counsel for the State Bank of India, his name is not shown in the call history.
Who's appearing?
Shown.
M. Sharma.
K. Barua.
People. Name shown in the call.
Name is shown, I think.
They filed a
Yes, they filed the affidavit also.
what?
Four, my lord, has filed the affidavit, my lord. SBI branch manager of the personalized branch.
If not,
Not.
Okay, affidavit is filed.
are you aware who's appearing?
The affidavit has been filed.
Affidavit has been
Are you
filed.
aware who is appearing?
Yes, my lord. The junior
Name.
SBI.
Kamal Burman, my lord.
K. Burman is
K.
the one.
K. Barua is
K. Burman is one.
No, she is with me.
1 to 3. What is that? My lord, I am not aware, my lord.
Findings of the ombudsman is on the basis of the materials supplied by the State Bank.
But my lord, my grievance is that, my lord, it is in the nature of the award. While passing an award, my lord, at the last part of the award, my lord, the ombudsman.
You have also filed affidavit, Mr. Barua?
Yes.
Yes. Respondent six.
Ajit Das. Ajit Das. Who is Ajit Das? SBI counsel.
Yes, yes. Filed by Ajit Das. Ajit Das' name is also shown, my lord. Yes, yes. Name is shown in the court.
Acha. There may be some hotel. Normally we say they also appear.
Yes, yes. Yes, yes. Yes, yes.
Okay, it will not set up parties.
Otherwise, pleadings are exchanged.
Yes,
pleadings are exchanged, my lord.
We have admission hearing.
My lord, my lord.
And in the meantime, we try to locate the Ajit
Ajit
Das.
Das, my lord.
He had appeared on the last page.
Yes.
They submit by the counsel for the party that pleadings have been exchanged on the matter and dispose of the admission page. So that today, however, the learned counsel for SBI is not present. In view of the above, command this case for admission here. On when
Any hearing day, my lord, if possible, my lord.
on 12th of September.
My lord.
In the meantime, try to locate
My lord.
Public.
Public.
The petitioner is the Vice President of the Jorhat Jila Parishad, my lord, and he was removed, my lord, in a very flimsy gown, that too without signing any reason, my lord, proper reason, my lord. And my lord, that's why I'm before your lordship. And in the meantime, my lord, they have selected another at the time of filing when I filed this writ petition, my lord, in the meantime, my lord, that post has been filled up. That's why, my lord, no stay was granted. That's why, my lord, I have an agency, and because, my lord, your lordship.
You're a vice president of
Jorhat Jila Parishad.
Jorhat.
Jorhat. So I was so close notice was issued, my lord, and I give reply. And your lordship kindly see, my lord, on the ground, what is that?
Your removal was by no confidence.
No, there is no confidence. In respect of Jila Parishad president, vice president, my lord, there is no, my lord, there is another mood is also
Section
there.
74 of Panchayat Act.
In 20, my lord, allegation me, my lord, why I was removed, my lord. Allegation is that I was not present in the, my lord, 30th January flag hosting meeting. That was, my lord, in 21. Thokos was in, my lord, 2022. 23, my lord. Oh, yes, I was absent in 2020. That is their allegation. And Thokos was after 2 years, my lord. Then I denied, my lord. So I was there, not, that is not, facts is not there, my lord. I denied, my lord, that was not been only on one line, my lord. There is no reasoning why, my lord, it has been removed, my lord. Please.
You said that you were present on 26 January.
My lord, I denied that, yes. They have, your lordship kindly see, my lord, only one line they have, my lord.
Now somebody else is running the
Yes,
show.
my lord, I made him party, my lord.
But don't you think that reason for removal?
We have filed detailed affidavit, my lord.
Isn't it
No, my lord, they file affidavit, but not denying, my lord, my main parameter.
Even if the charge not denied, don't you think that this as a vice or
no
difficulty that assuming that he has
My
not
lord,
come,
after
you directly remove him.
after the complaint, my lord, the deputy commissioner had made an inquiry. Inquiry was sent to us, my lord. Thereafter, we have thought the judicial department's view.
Is it the only reason, or is there any other?
My
Is
lord,
there-
this
is
is
it
the
the
main
only
reason.
charge?
This is the main reason.
Only charge.
This is the main reason, my lord.
Don't you think that judicial conscience?
No, my lord, that is only reason, my lord. Your lordship kindly see only reason, and in fact, my lord, the inquiry committee report was not submitted to me, my lord. In by that I made a statement that is not only denied, my lord. Your lordship, may I read the, my lord? Your lordship kindly see page 56, my lord.
Of the repetition. Why two repetition?
Do you know, my lord,
President and Vice
president and vice president, my lord. When, my lord, they are Congress, and now when BJP in power in 2018, my lord, this has been done, they will remove, my lord.
That is not correct, my lord.
No, my lord, your lord,
You tell us who are the
petitioner, they are elected, my lord, Congress member, my lord, as a Congress candidate.
again.
No, my lord, there is a elected as a Congress. That's why they are elected, my lord. They are president and vice president, my lord.
These are something which is
But that is the main behind this, my lord.
we are not
My lord. No, that's why, my lord, I'm submitting, my lord.
Inclined to go by those reasons. You tell us who is Basav Kakolita.
Yes.
He is,
There is a vice president of the Jorhat Jila Parishad.
and both of them are removed.
Yes, vice president, vice president.
Vice president and president.
President.
On the same ground.
Same ground.
Same ground.
Same ground. May I just your lordship kindly see page 56, my lord. Page 56, last dash 2, my lord. Only 2 lines, my lord.
Which petition?
Page first petition, my lord.
5430.
Yes, my lord. 5430, my lord. Page 56, my lord. My lord. Last but 3 para, my lord. Whereas also peruse the reply submitted by Vice President Jorhat Jila Parishad during his personal hearing held on 15/7/2022 in compliance with the Honorable Court Order dated so. Based on the aforementioned fact, the Vice President Jorhat Jila Parishad is found to be guilty of disgraceful conduct not attending the flag hosting ceremony on 26/1/2020. That is the only line, ma'am. That is my lord. Where is my affidavit, my lord? My reply, nothing has been stated here. That is the only line. That is the only finding, my lord. Others are fact, my
Did you attend or not?
lord.
Did you attend or not?
My lord, I attend, my lord. I denied, my lord. Your lordship kindly see.
Did you attend?
Yes. Your lordship
We
kindly
are
see my
not
reply.
we are not interested in your denial. We are asking a very positive question.
My lord.
Did you attend the flag ceremony?
But from, yes, from his reply, it is attend, my lord. Your lordship kindly see. That's,
You were there on the spot, or from whom you had it?
my lord.
You were there on the spot or not? Were you present at the spot? Where the
Yes,
flag-
my lord. I am present, my lord, and that's why, my lord, your lordship kindly see to end
Where
20.
Where will you sit?
Yes, para 54, my lord. Page 54, my lord.
No, in your pleadings.
Of the pleadings, my lord. Pleadings, I am relying on the, my lord. No, your lordship kindly see one aspect of the matter, my lord, para 12, what I am submitting, my lord. A very interesting, my lord. Para 12, my lord. The petitioner respectfully beg to submit that as per so-called notice, the petitioner has submitted the reply in writing by annexing all supporting documents. But same was not properly considered and also not time for hearing a petitioner. Also oral reply was not accepted as well as considered by the authority concerned. That para was not denied by the authority, my lord. Para 12 of the merit petition.
That is okay, but where
Then, my lord, your lordship kindly see my reply to the so-called, my lord.
Yes, page.
Page 54, my lord.
Yes.
That with regard to the point number E, the so-called notice dated 26/5/20, it was vehemently denied by me, and I was not present in the flag hosting ceremony on 26/2020. If so, the authority might have cancelled my explanation at the time at that time. But last 2 years, authority concerned was sitting over the matter and doing nothing. Now they rise with this allegation. Expired after 2 years. It is so itself inspector since I am fully attending the successfully here in the flag hosting ceremony. Your lordship kindly see that's why in fact they are asked to produce the record also.
From when was the pandemic declared?
Declared probably 21.
March. Another 1 to 2 months. March.
No, actually, yes, March.
March 21st. No, 21st of March of 2020.
Oh, yes.
Tenure is expiring.
No, I am not on that, my lord. Even in expiring, I will fighting because they have the gross illegality they have committed.
Para 12, we denied, my lord. That our affidavit, page 86, para 9.
Para page
86. Paragraph 9.
9 and 12, sorry, they have alleged, no?
paragraph 9.
May I read, my lord? Second line, my lord. It may be mentioned that as directed by the Honorable High Court in its order dated 10/6/2022, passed in so and so, the state government refrained from taking any coercive action against the petitioner till the receipt of her replies to the so-called notice. Further, in compliance of the Honorable Court's aforesaid order, the petitioner was also given personal hearing, wherein the statements made by the petitioner was recorded, which was also duly verified by her. Based on the findings of the Deputy Commissioner Zurhat into the allegations against the petitioner, and also based on the statements recorded during the personal hearing, the order that was passed.
That deputy commissioner inquiry report does not submit to me, my lord.
Also, judicial department's view was also taken, my lord, and the approval from the minister also taken.
We are not on the Sure, let us see this show cause notice again.
There are two show cause notice, my lord. The lordship kindly see, first show cause notice was issued on, my lord. That is
Page 19.
page 19, my lord, annexure 2. Annexure 2. That was by Deputy Commissioner.
This is before the preliminary inquiry, my lord.
Ultimately, what is the main charge?
These are all same charge, my lord. The second show cause notice given, my lord. That's why I came for this honorable court.
And what is the main charge?
Main charge, my lord, that is, they have already argued on only that you have not attended the flag hosting ceremony on 26 January.
Let us see the impute order.
My lord.
Yes.
Whereas Peru the chief executive, page 55, my lord. Page 55.
What is the date?
Page 55. That is, my lord, dated, my lord. This put 6 August 2022.
It also talks about some no confidence.
That is, they have written back, there is no.
But that's not the only charge.
No, my lord, there's your lordship kindly say findings, your lordship kindly say finding only on that. Whereas that is the charge they have mentioned. But whether it is proof or not, or disprove everything, nothing. Only that not present in the meeting. No confidence, there is no confidence.
No, see, this order, so there is a finding that you have not attended the official program of 26 January. But there are a number of charges. Let us see charges.
My lord.
At page 19. There are as many as 7 charges.
I agree, my lord. But here is on impugn order, my lord. They have mentioned only one, and they have said that there is an inquiry by the deputy commissioner. But that inquiry report is not been submitted to me, my lord. I have a categorical statement I have made, my.
See, you come to the charges at page 19.
My lord.
We thought that was the only charge of not accepting.
There are other
six other charges.
Yes, my lord. But what is the finding on that, my lord?
Yes, what do you say on the other charges?
So I shall produce the inquiry report, my lord. In the affidavit,
Where is the file?
we have not annexed the inquiry
That
report.
was not been supplied to me also.
Get the file, get the original record.
My lord.
So you were on a different footing then, as if that is the only charge. Now it appears that there are other charges.
My lord.
We want to see how you have dealt with the other charge.
My lord.
Because not attending 26 January and removal from office, I think that would be disputed.
My lord.
But if there are other charges which also relate to not attending the office and absent on some crucial days where no confidence motion was held, not giving relief measures. Mr. Mahanta, in page 19,
my lord,
See, not anything. The particular function is only charge number 6.
Yes.
There are other charges also.
Lord, you may kindly
Much
come
more
to
important
page
charges.
number 42 for my movement.
40.
This is the so-called notice issued by the government, my lord, as per mandate of the section 74, my lord.
42.
Yes. There are
five
charges after the inquiry report of the deputy commissioner. And after this so-called notice, the impugn order was passed. After he personally had.
He is only one of the charges.
Yes.
Yes, my lord.
That you have dishonored the national program like Republic Day by not attending. But there are other charges.
The other charges there, my lord, but I have given explanation to the other charges, but they have not considered my explanation and there is no finding on them.
Doctor,
I'll produce the record.
Initially there was a district inquiry on a fact find.
Well,
Based upon that, 26/5/2022 has been served upon. He has shown cause. And as per Mr. Mohanto, the allegation on which the punishment is imposed appears to be one for not attending the Republic. But there are 4 other allegations. We want to see how we have dealt with the allegation.
my lord.
If we think that you have not dealt with this allegation, that penalizing him only on that ground perhaps will be too hard. But if you have dealt with this allegation, then we take some other. Bring the record. Bring the record.
One more problem is that, my lord, as per section 74, there are no other punishment, only one punishment, removal.
Removal on what? What allegation?
My lord.
Can you remove because some very minor thing has happened?
My lord. I can
After all, he is the elected representative.
My lord.
Otherwise, how can you remove from Jila Parishad? How can it be removed? No evidence for no confidence.
No, there is a provision.
No, there is a provision for
Yes.
no confidence.
Yes.
Elected representative, you can't beat him or have a no confidence. Removal of an elected member, that is something extraordinary.
My lord.
Third,
After new elections were held for the election of president and vice. Out of 19 members, 17 members were elected. So he has lost the seat for all purposes. That is additional charges to the notice of the. Out of 19 members.
how are president and vice president elected from the members?
Yes. Member.
From the members only.
From members
No,
of the
first you have to, not like a president.
Of the government.
Yes,
It is not
government
direct-
president
it is not
directly, my lord.
directly elected.
But here, my lord, among them they have to elect.
So out of 1917 has elected.
No, they were not there in the fray, so how do you elect them?
No, they were also there.
How can they be there? They are already removed.
They were removed.
Removed
Then
from
I
pres-
came in. Out of 19 members, 50 members. Elected. I'll say that.
No, that
That
will
will not
that
do
will
in
not
the
make
inquiry.
any difference. He was not even in competition. He was out already. How many persons did the contest for it? In the second round. After his removal.
In fact, there is no election. All are, my lord.
Only me, my
That I am not going to that, my lord.
I contested. It is held on the basis of the meeting called by the deputy. I'm just putting.
Have the record. Petition. Also heard as the he appeared at he did a present for the private respondent in both the cases. The demands of the petition for respect and price of Jorhat Jila Parishad is against the removal. Person also was that taking into consideration nature of allegation and ground based on which the litigation has been structured, the record of proceeding would be necessary.
No, already there is a order, my lord, passed by this honorable court, my lord.
Please
Already
also,
there is a order.
the understanding of the record, will record produce the record, will record procure the record, and place the same for produce the on when
December first week, my lord.
on 7th of December.
Yes, yeah, I can put it.
Sada,
Nine.
7th.
Develop.
That is a lot. I have filed my rejoinder, my lord. And my lord is likely to dispose of the matter today, but it is
they will
not able to. Yeah, short date.
what is the matter?
Matter, my lord, petitioner is a petty businessman, settled one vita in the Martin Bazar market under Binna Gandhi under Anshalik Panchayat. And my lord, Jila Parishad, my lord, constructed some rooms, my lord, market rooms there.
Sir, Dappa has said that they are also earlier
Yes.
holders.
So page 38 of my affidavit, my lord. This is the minutes of the meeting, my lord, standing committee of my affidavit.
Do you have any enforceable right?
My lord, the settlement holder, my lord, since 35 years,
It
there,
has
my
not
lord.
been somebody else there.
And they are, my lord, they have promised me that you vacate the land, we will give a
No, but if you
market.
remember correctly, the doctor had submitted the other day that the persons who have been given the
My lord.
allotment, they are also settlement holders.
No,
They are-
no, my lord, they are not the earlier settlement holder. Illegally, they are allotted, my lord, without any procedure or law, my lord.
Yes, what you say?
My
My
lord,
lord, may
kindly
kindly
see
see page 38, my lord. This
page
is the
thir-
minutes of the meeting, my lord.
Yes.
Resolution 4
Committee has
decided to lease those rooms to the people who had occupied the vita before the rooms were constructed as follows.
let them show the.
These are the
their-
5 persons, my lord.
If they are, and kindly see the 39, my lord.
And
Page 39, my
this
lord.
was decided by the standing committee, my
The-
lord, not by the government
Chief Executive Officer is
department.
absent, my lord. The ex officio secretary, my lord. He was absent in the meeting. Without ex officio secretary, how they can tell the meeting, my lord, and kindly see that there is no any tender of notice inviting my lord tender from the settlement holder.
They have to make them party,
Yeah.
my lord. The 5 selected persons.
These persons are not party.
No, my lord.
One, my lord, I was not, I am not aware about the person, my lord. Only one person, my lord.
There are two private persons, Mr.
Who
Arya,
is
7 and 8.
Nawazuddin,
No, 7 and 8. Nawazuddin.
Nurul Haq.
Yes.
Nawazuddin is the
There are 5 persons.
member Hojai Jila Parishad.
Yes.
And Nurul Haq is the settlement holder, newly settled, and he was not the earlier settlement.
And Nurul's name is at page 38, serial number 1. Resolution 4.
Yes, madam.
Yes.
But they are disputing. They say that these are the persons who were occupied the Gita, before the rooms were constructed.
My lord, kindly let them produce the record, my lord. I produce my,
Where have you stated, Mr. Dr. in your
My lord,
affidavit?
my lord.
In your affidavit?
Yes, my lord. Paragraph 3, my lord.
Those rooms were occupied with the scope of
And I-
interference. Scope of interference is minimal, Mr.
my lord, kindly see my affidavit in reply, my lord.
Okay, we'll have that.
Affidavit in reply, my lord, can you see? Paragraph 4.
So this is a short matter, we can discuss it.
Yes, my lord.
Day after tomorrow?
My lord.
Day after tomorrow, my lord, from Friday.
I have also
Any
some problem.
hearing.
No. Tomorrow?
Tomorrow I have some difficulty.
Next Tuesday, my lord.
Next Tuesday.
7.
We'll have it on 29.
Or any hearing day if possible.
29.
Hearing day, my lord.
Hearing day will be on 29.
29.
Buildings have been taken up for as expected by it's on 29.
Lab police affidavit is required, my lord, in this case, my lord.
Why?
Because Jilla police settle the market, my lord. As
Same stand. We have same stand, my lord.
Yes, next. That matter.
Last order, Lordship, past 11:10.
Anything has happened?
I don't know. They are supposed to submit the inquiry report.
Inquiry has been done, Mr. Nayak?
Yes, inquiry has been started. In fact, one later dated 7 November 2023. It has been directly written to the Registrar Guwahati High Court Lord. Preliminary inquiry has been conducted, Lord, and they are saying that some more days of time is required.
And what about your current salary?
They are
3 months salary they have received. 3 months.
that is not good.
Lordship, direct to submit the report.
Yes.
And in the
Pursuant to the order dated 11/10/2023 passed W19 of 2023, an inquiry committee, the inquiry committee has constituted that Sri Nayak, P. Nayak, council representing the Storage Board.
No, one in
Which department? Housing and Urban Department. However, submit that some more time to be done. Some more time to be required for completion of the inquiry. And according to this for 4 weeks per time, this court has informed with regard to the aspect of payment of salary. This court has informed that the petitioners have been paid salary
3 months
for 3 months in WPC 1989 and the petitioners, the other 2 cases are being paid their regular salary.
Yes. There is an interim matter. Interim may be continued.
This after 4 weeks for completion of the inquiry and basic report. This report and still cover. Order passed.
In regards to 32 and 34. Well, date may be fixed, my lord. A date may be fixed, your lordship. Date এটা লৈ লওঁ ন।
Hello?
January, my lord. For
In the month of January.
After, yeah.
After one. Before Bihu.
Before Bihu, my lordship.
We'll have it on 5th of January.
Highly obliged.
Friday. Press matters, date should be given.
My lord, one matter, very urgent matter, item 37.
And my
What is the urgency, Mr. Sharma?
My lord, there is no confidence motion, my lord, the period of the tenure of the Panchayat ending in March. So can it be taken on
Friday? After tomorrow?
Lordship, yes. Friday.
Item number
Item 37 Friday.
item number 49, Lord. Friday is some difficulty, man. Same matter. Can it be on Tuesday, man?
Yes, at 28.
28 or 29?
On Wednesday.
Wednesday.
Item number 30, sorry.
29.
My lord, item number 39, my lord. It was supposed to be, if my lord, both sides have filed affidavit, my lord. Can it be next week, my lord, any convenient day, my lord? 28 will be hearing day.
Okay, we'll give a date. Any matter,
item number-
the interim order is
Lordship,
pending.
item number 41.
My lord, item number 49, my lord, content matter. Nowadays, my lord, instead of a listing matter in the motion, my lord, it has been listed for orders, my lord. Today is the second day, my lord. And matter has not been.
Okay, next date you make a mention. We'll take it up just after the motion.
Lord.
Day after tomorrow.
Yes.
My lord, item number 41, there is an interim matter
41.
and that will be continued. And I am praying for listing of the matter on
Date we'll give the interim.
My lord, I have a prayer. In fact, my lord, due to the interim order, my lord, in fact, now the society is without a board for more than 6 months. Under the act, your lordship is aware, beyond
Okay,
90
day after
days.
tomorrow then.
The next week, my lord, any
Yeah,
day.
day after tomorrow, Friday.
Yes, yes.
Friday.
Oh, Friday, my lord, some difficulty. Can it be Tuesday, my lord?
Then Wednesday.
Wednesday, my lord.
Wednesday, item
Or
41.
Thursday, my lord.
41.
Can it be on Thursday?
Tuesday, Thursday. Wednesday.
40 and 41 are taken. 40 and 41.
Yes.
Item number supply 61. Kindly.
So far, item number 36 is concerned, my lord. Council for Petitioner is there. Not Friday, my lord. After 2
We'll
weeks.
give date. Don't worry. Date we'll give.
After 2 weeks.
Date. Item number
36.
36 was mentioned. No, it's not. 30 will give date. Don't worry.
Item.
Any matter where interim order is still today,
No, I
then
think
date court must will give.
Item number kindly is 61, supply 61. Kindly be the day after tomorrow.
We'll give date, not day after tomorrow. Is it a
Monday,
new
Monday.
matter? Is it a new matter?
No, we are review petition. Opposite party is also there.
Item number 38, kindly fix it.
61 Monday. No?
Item number 38. Kindly fix the date.
We'll give the date.
Lordship, item number 50 and 51, this is wrongly listed for admission, kindly list for Moscow.
For contempt matter.
Contempt matter.
Contempt will come for orders. You make a mention on the next date. We'll take it up after tomorrow.